Honorable Commissioners, we can now start our session. Our candidate today, and has already joined us, is Senior Counsel Freddy Ngatia. Welcome, Mr. Ngatia.
Thank you.
And thank you for availing yourself. We'll take a few pictures of you, or I don't know whether Anna, that has been done. Yes, we'll take a few pictures, Senior Counsel, and then you will continue with the interview. Yes, I think that is enough. We can continue. Mr. Ngatia, now I'll have the commissioners introduce themselves to you, and I'll start with the acting CJ.
Good morning, Senior Counsel.
Good morning, DCJ.
I am Philomena Mbetemwilo. I am the elected representative of the Supreme Court to the Judicial Service Commission. I'm also the Deputy Chief Justice of the Republic of Kenya.
Thank you.
Good morning, Counsel.
Good morning, Commissioner.
I'm Patrick Shohei, representing Public Service. Karibu.
Asante.
Good morning, Senior Counsel.
Good morning, my lord.
I am David Majanja, Judge of the High Court, Commissioner representing Kenya Magistrates and Judges Association. You're welcome.
Thank you.
Good morning, Senior Counsel.
Good morning, Commissioner.
I'm Olwande Evelyn, Chief Magistrate. I'm the female representative of KMJ.
Asante.
Good morning, Senior Counsel. My name is Macharia Njero. I represent the Law Society of Kenya.
Good morning, Commissioner.
Good morning, Senior Counsel. My name is Felix Koske. I represent the public.
Asante, Commissioner.
Morning, Senior Counsel. My name is Mohammed Warsame, Judge of Appeal. Welcome.
Asante, my lord.
A very good morning, Senior Counsel Fred Ngatia.
Good morning,
Kariuki. I am the Attorney General, and I'm here by virtue of that office.
Asante, sir.
Senior Counsel, and I'm Olive Mugenda, Commissioner representing the public and chairing these interviews. We also have the Secretary to JSC and also the Chief Registrar of Judiciary, Honorable Anna Madi.
Good morning, Senior Counsel.
Good morning, CRJ.
And we also have Frida Mukaya, who is the Registrar of JSC, at the corner there. Thank you. So a few housekeeping issues, Senior Counsel. Please feel free to ask commissioners to repeat a question if you're not sure, or to clarify. After 2 hours or so, we will have a short break, and Madam Anna Madi will escort you to where you're going to have your break. Otherwise, it's supposed to be a conversation, Senior Counsel, so you should all relax and have the conversation. So I'll kick off the interview by giving you 5 to 10 minutes, Senior Counsel, to tell us why you feel you are the best suited candidate to be CJ. And I will just 5 to 10 minutes, because the other issues will come with the commissioners. Thank you.
Asante, Professor. Perhaps I should first and foremost say I started my legal career at Attorney General's Chambers in 1980. That was the first place I was employed. Within a relatively short period of time, I was allocated very many difficult briefs. I'll mention only 2. I was involved together with the head of station head of my section, Mr. Frank Shields, with the acquisition of the land where Kasarani Sports Complex is constructed. The owners of that parcel of land, a company called Salopia Limited, had objected to government acquiring that land because we were using the Land Acquisition Act. And it's a prerequisite in that act that when government is using that act, it's got to be for a public purpose. And because of what was then happening, the owners were saying, this is nothing more than government taking this land for its own purposes. We did overcome that formidable challenge, and after overcoming that challenge in the High Court, then we went on to the issue of compensation. It was handled by the chief valuer, and that is why this republic has a near Olympic stadium at Kasarani. Soon thereafter, Attorney General nominated me to look at a very difficult problem that has persisted in this country, or had persisted in this country from the time of independence. That is the difficulty of an international boundary between Kenya and Sudan. I was entrusted with that task. Ultimately, government, together with the British Council, sponsored me to undertake a Master's in Law program at London School of Economics, and as part of the LLM program, to undertake original research in Kenya-Sudan boundary. I was at LSC. I spent numerous hours at Public Records Office because commissioners, all the documents of this republic during the colony and protectorate status, all those documents are at Public Records Office. I'm sure commissioners, you know where Public Records Office is towards Heathrow Airport at Kew Gardens. So I had to commute from LSC, which is at the Strand, and go to this Public Records Office every other single day, and I acquired a wealth of material. In 1 minute, commissioners, at the turn of towards 1914, the boundary was defined by the British government as a straight line between two fixed points, or in the alternative, such a line that would give to us the customary grazing grounds of the Turkana. Those grazing grounds were never defined, but towards 1938, a survey party established that the boundary was slightly above the straight line. That was not to be. We went on, and Sudan demarcated what they call 1950 Sudanese patrol line. That Sudanese patrol line is what actually triggered my interest in this area. And by application of principles of international law, I actually established that when any government allows a competing government to administer an area, the doctrines of acquiescence, doctrines of renunciation of territory, they all kick in. I hope we'll have an opportunity to discuss this in greater detail, but in one sentence, we were able, or I was able in my research, to establish that the Sudanese patrol line, which is a considerable distance from the straight line, is now the international boundary. So, commissioners, I'm sure you all remember, in 1980s, the Kenya-Sudan boundary was indicated as a straight line. Then in 1985-86, we had an extended boundary that went towards Sudan. The difference in graphic terms is that through this research and the validation that went on in government, we were able to change our international boundary from the straight line to the new boundary, and we acquired 9,680 square kilometers To put it in context, the former Western Province was 7,400 square meters. So we acquired a territory larger than the former Western Province. This is one of my research papers. It went through government, it went through validation. I cannot say that it was singular effort. The Attorney General and other organs of state all participated, and ultimately we changed our boundary. I then went to private practice from 1987. I've conducted numerous cases. Of interest would be I acted for ECK in the Kriegler Commission and also in the Waki Commission, where it was demonstrated that weak laws, weak institutions, weak governance structures can actually collapse any republic. Kriegler Commission report demonstrated and illustrated the weaknesses which were within our legal system and the lack of capacity in the electoral process and the lack of independence in the judiciary. I was part of a team. My team leader was John Musyoka Annan. I was his able assistant, and we also had Nyamodi. Paul Nyamodi is one of my colleagues. A team of 3, we represented ECK. It was a gigantic effort. We learned so much about the need to have proper laws and proper capacities in key institutions that deal with elections and the need to have an independent judiciary. Professor, thereafter, I've given my CV. I was instructed to work for National Assembly, and this is interesting, against the Senate in an advisory opinion at the Supreme Court. You may remember that there were the tough wars at the beginning of the 2010 Constitution, which is the superior house. But like lawyers, we do what we know best. We posed what appeared to be a very innocuous question. Which house should originate a money bill? But behind that innocuous question was whose business is it to legislate division of revenue bill? Because if it came to be my client, National Assembly, to legislate division of revenue bill, it means then we're in total control over devolution. And Senate was saying, no, it can't be. It is a joint effort. We came to Supreme Court, we argued on this matter. I lost, but with one dissenting judge saying that the issue was not justiciable. With that loss, devolution became entrenched as a principle that must be followed. But that was not the end of it. Barely 2 years ago, I was again instructed by the Council of Governors also about division of revenue bill. This time because the opinion that had been given to both houses was being ignored. I did that matter, and the Council of Governors was quite happy with the outcome. In between, I have conducted many other cases, and in my view, if I could summarize in 1 minute, you've had a CJ from academia who did wonderful work. I've looked at his transformation agenda. Allow me to say this with tremendous respect to my former lecturer. It is as profound or second in as profound to the Constitution. I can't see any other agenda as profound as Chief Justice Mutunga's agenda. Then you had a judge of this court as a Chief Justice with his agenda, which took us to another level. We have more magistrates, more judges, courts all over the country, a wonderful experience. But what you now lack is somebody who has been a consumer of this service. I've been knocking at the doors of the High Court, Magistrates Court. I've been to all the courts in this republic. I have that eye that no other would have. For 40 years, I've been in Magistrates Court everywhere. I've been as far as Lokitang. I've been in every part of this country. We had 14 High Court judges at 2011. I've been to each of those. I've been to every Court of Appeal station in this country. When Supreme Court started, I was one of the early practitioners in that court. I have practiced in that court. I have wonderful professional relationship with the judges of that court. And I do believe, Professor, that I have that eye, a practitioner's eye, that can be able to see the real weaknesses and the perceived weaknesses and come up with a transformation agenda slightly advanced from access to justice. From access to justice to another agenda that would be, which we will discuss as we get along. Thank you, Prof.
Thank you very much, Senior Counsel. Clearly, Senior Counsel, you are a successful lawyer, Senior Counsel by all standards, given what you have told us and also what you have read from your CV. What I haven't heard, as Senior Counsel, that I want you to explain to us is I've not seen much evidence of Mr. Ngatia, the leader. So please demonstrate to the Commission and to the public that you are that transformative leader we are looking for. I'm interested in tangible achievements in leadership and also maybe institutional changes that you have done, and that can be attributed to your leadership excellence, Senior Counsel.
Thank you, Prof. Prof, of course, I must also acknowledge your transformation of an ordinary college to iconic status. So allow me to pick a college, a university college, as an example. I have so many examples, but allow me to take a university college. Commissioners, you may all recall, University of Nairobi, virtually every now and then students will go on strike. It became so perennial that we were wondering whether we should have a university next to the human population around the city of Nairobi because of the rampant wastage that used to happen. About 3 or 4 years ago, I was requested by the Senate to look for what are the issues bedeviling this university. Prior thereto, I had been involved as counsel in a lot of disciplinary cases that went to the High Court. And those disciplinary cases used to have almost a circular effect. You discipline a student, expel him, and then that provokes a riot at the campus. You do not do that, then again another circular effect. And when Senate engaged me with a student population of 80,000, I started working with the university administration. Prof, at University of Nairobi, there are 8 colleges. No, sorry, there are 6 colleges. Each college had its own independent disciplinary process. So you'd have a college, for example, Humanities and Social Sciences at the main campus, with near to 18 faculties under it. You have another college, say Biological Sciences or Agriculture at Kabete. Each of the 6 colleges would have its own disciplinary structure. Then for the halls of residence, there were 8 distinct. Consequently, Honorable Commissioners, you have, so to speak, semi-autonomous pockets of disciplinary bodies all dealing with the 80,000 students. And of course, what will go to the academic, the colleges, would be anything to do with academic, but for residential, it's what would go to the halls of residence. I studied this, I engaged all the colleges, we had seminars, and we had so many workshops. And then I looked at comparative colleges like Pretoria, Harvard, my former college, LSE, or University of London, and I actually saw what is the problem with this premier university. It's the 7th university in Africa, but they had not got it right. You cannot have a disciplinary process which has no harmony. So what was ailing this college is the fact that there was no harmony in the sentences that are awarded to students. There's no harmony in what is a disciplinary offense. And I crafted a student handbook that was to operate and is to operate across board. So you do not have a student in one college being expelled, whereas for identical offense or misdemeanor or transgression, he is just told, do not repeat that again. Consequently, and I say this without any fear of contradiction, the harmony you now see at this university is a direct attribute of the work that we did. I must, of course, acknowledge that I've received tremendous support from the Senate and from all the college principals and all the academic staff. We were able to actually transform what was becoming more or less a perennial problem of indiscipline to now a college where I'm sure commissioners, you cannot recall the last time you saw university students throwing stones along Koinange Street. And I have many, many other examples of equal kind that I've had occasion to deal with.
So, Senior Counsel, were you the chairman of the board of the council of Nairobi University? Or?
No, whatever work I did as an consultant.
Oh, okay.
I did as a consultant at the request of the Senate. I was reporting to the Senate, and they authorized me to have meetings with any person within the university. So I started off with the academic staff, and then went on with the college heads, and then as we went along, I got across a very, very good idea of why indiscipline had become the order of the day.
So, just a follow-up question, Senior Counsel. You're going to be leading a workforce of probably like 5,000 judicial officers and judicial staff. So how will that experience then help you to lead this big workforce in the judiciary?
The principles in leadership, Prof, commissioners, apply for a workforce of 20, and they would apply for a workforce like the Boeing aircraft manufacturer. It is all a question of how you are able to be a leader. I should have indicated that later in life, I did a second master's degree in applied philosophy at Strathmore University. In that, I learned business ethics, philosophy as a tool, and leadership really clearly understood what you are looking for are the 4 cardinal virtues. The 4 cardinal virtues are prudence, temperance, fortitude, and justice. If you have the 4 cardinal virtues, you'll be a leader of 10, a leader of 100, a leader of 1,000,000. It is not administrative skills, it's leadership. And in leadership, you are looking for the 4 cardinal virtues. And this is an applied principle in all the blue chip companies all over the world. We had an empirical research at Strathmore about who are transformative leaders in all the companies in the world. And what stands out is somebody who manifests in deed and in word that you have the 4 cardinal virtues. I can say without any fear that I have tried my very level best to manifest and to inculcate the 4 cardinal virtues in everything I do. Before I conclude, from the 4 cardinal virtues, you collapse into 2 other, so to speak, abilities that you must work on, which is humility and magnanimity. So from the 4 cardinal virtues, on a day-to-day applications, there must be humility and magnanimity.
Thank you, Senior Counsel. You talked about the vision a little bit when you said that you move from transforming judiciary from access to justice, move it forward a little more. Please talk a little bit about that, your vision, and how you are going to rally all the stakeholders behind you to achieve that vision.
As a consumer of the service, as a consumer of this service, and here I must say that as a consumer, I have that little more knowledge because I've been to virtually every court. And we are able to see how that court operates, how another court operates. I've been a victim of delayed judgments. I've been a victim of all manner of things. And with like measure, I have a lot of very good things to say. Before I say anything further, let me acknowledge, Prof, that in our judiciary, we have some of the best legal minds. And I do not say this in flattery, because I have had the occasion in my second master's program to do a research paper on jurisprudence in apex courts all over the world, on very, very toxic or very difficult subjects that happen in our life. This is the end of life litigation. I've looked at America, the Supreme Court of America, Supreme Court of all the countries in the world. We have fantastic judicial minds. What is it that I'll be able to bring which is not there? Access to justice was very well done by the first Chief Justice. Second Chief Justice did as much as he could. But access to justice is both qualitative and quantitative. It's not enough to have courthouses. It's not enough to have many judges and many magistrates and many tribunals and everything. What we now need is another transformative agenda: expeditious disposal of cases. Expeditious disposal of cases is the one that will take Kenya to the next level. It is heartening to hear of cases staying in the court processing, being processed in court for 10 years. We should be looking at a possibility of a case, and we can do this, and I've listened to other Chief Justices. I'm a keen listener of the Chief Justice of South Africa, Mogain. And what he's trying in South Africa is a case management system that can process a case from filing to the determination of that case. Why we must have this is because without it, we will never know statistically how well we are doing. That would be my mission and my agenda.
Okay. Thank you very much, Senior Counsel. One last question from me. In your CV, you have said that you have avoided to be a conspicuous consumption person. But please explain what you meant, because looking at your wealth declaration, Mr. Ngatia, I saw very high-end cars. So isn't that conspicuous consumption, or what did you mean?
No, Prof. Conspicuous consumption has many aspects. I meant social circles. I meant that I am not in social circles. I'm not in lots of the new approaches in life. I do prefer to hold to my own. I prefer the solace of being in a library as contrasted to being in a social circles. And I must say I'm one of those lawyers who are not on the social media, any of the social media platforms. I'll prefer to hold my peace, and therefore I indicated I'm not in those social circles. And I do not mean to say that those who are any less or doing any worse. It's a question of choice.
Thank you very much. I'll now request Commissioner Mwilu, acting CJ, to ask you further questions.
Thank you. Let us conclude the discussion, Senior Counsel, that you have begun with the Chair on leadership. And that leadership must of necessity lead to the reforms that we have already begun and which must be continued. And since you appear to admire Chief Justice Mutunga, let me start at that point. On the 19th of October 2011, when Chief Justice Mutunga was addressing the judiciary and the nation at large, he said the following words. And I quote him: "We found an institution so frail in its structures, so thin in resources, so low in its confidence, so deficient in integrity, so weak in its public support, that to have expected it to deliver justice was to be wildly optimistic." Now, we want you to please put that into context, Senior Counsel, in terms of the transformation, not what has already been undertaken, but the transformation that Senior Counsel would progress, were God to grant that Senior Counsel becomes the 15th Chief Justice of the Republic of Kenya.
Yes. Chief Justice Mutunga, I think, was being very philosophical with certain words. Being low in public support, I can see that as a direct attribute of the events 2 years or 3 years prior thereto, where the public support to this institution was at its lowest level, culminating to a presidential candidate declining to have his dispute litigated in court. And with that came lots of other events. And one of the issues that I would wish to deal with, and that is why I would wish to gain public support, is that if a case is filed on 1st January, within that year, it should be concluded. Commissioners have also done a little bit of reading, and we have real-life problems in this country. I saw for example, in Costa Rica, an empirical study which has been done. If you get your criminal justice system working quickly, there is an immediate reduction in crime. But here, what we do is the exact opposite. We make our justice system work so slowly. Consequently, there can be a reduction in crime. If we wish to get public support, expeditious disposal of cases becomes a very important thing that we must implement. Deficiency and being thin on resources, I see that happening because it's at that time of Chief Justice Mutunga, I think judiciary had not had its pride of place in the Constitution. We also have the history we are dealing with. When I was joining Attorney General's chambers in 1980, judiciary was a department under the Attorney General. And that is why in the Waruhio Commission, he actually makes a direct recommendation: let judiciary be away from Attorney General's chambers. Therefore, the transformation journey not only is to divest or to have judiciary stand on its own under the Constitution 2010, but we also have its own independent funding structures. And again here, DCJ, I would wish to say all those tools are provided for. because there is a judiciary fund. And the Constitution of Kenya only establishes 3 funds: Consolidated Judiciary Fund and the Equalization Fund. Consequently, the framers of this Constitution want us to get away from the frail judiciary which was there in 2011 to a very robust judiciary, which is where we want or would aim to have this judiciary get into. I see Chief Justice Mutonga's words as words of hopelessness and frustration in one word, because across them it is the hopelessness of the situation that he's being confronted with.
Senior Counsel, then you would of necessity have to take us out of that hopelessness. Are we still there? That was 2011. Fast forward to 2021. Would you still describe the institution of the judiciary to be in a state of hopelessness?
Far from it. We have made such tremendous progress.
And therefore, then, Senior Counsel, what would be the role of Senior Counsel, were he to be Chief Justice, to move us from here to a place better than what Senior Counsel would have found by the time Senior Counsel was retiring as Chief Justice?
I see myself being in more or less the same position as Singapore was in 1980. Singapore had a huge backlog of cases. I have done a special reading of Singapore and the backlog of cases. And within 4 years, and everything being equal, I'm a Chief Justice of 4 years. Within 4 years, Singapore did overcome that backlog. But not only the backlog, simultaneously they put in place the process or the system I am craving for, that cases are being concluded within a relatively short period of time. Today, Singapore, commissioners, is being cited all over the world. They did this with some assistance from the World Bank, but I do believe, with or without that assistance, they had the mental, they had the determination to do it on their own. It's one of the shining examples of what can be done within a relatively short period of time within a judiciary that really is interested in moving forward. So to answer you directly, DCJ, I'll be the Chief Justice that will end the backlog and simultaneously have the expeditious disposal of cases, not as a theory, but as a practical thing. I would wish to see a criminal case started and within 6 months there is a determination. I would not want to be the Chief Justice of criminal cases staying for so long that witnesses disappear and acquittals are because of the delay in the justice system.
Thank you. I think let us pursue that a little. We have the justice chain players. How is my Lord Chief Justice Ngatia going to achieve a criminal determination within 6 months? Will Chief Justice Ngatia force magistrates or judges to go on with hearings where the other justice players are not playing ball? It is advocates who at times will seek adjournments. I'm aware the court is in control or ought to be in control of the case, but there will be genuine reasons for an adjournment. There'll be other maneuvers undertaken by the other justice players, the investigator, the prosecutor, so that the case is not ready and therefore not able to be finalized within this period of 6 months that Senior Counsel Ngatia proposes. What then, what then would Chief Justice Ngatia do to actually achieve a determination of criminal cases within 6 months?
Thank you, DCJ. Like everything else in life, it's not a one-man show. NCAJ becomes the first port of call. The beauty with NCAJ is that all the other players are involved. And it has got to be from NCAJ that a determination has got to be made that we must move this country forward. Judiciary actually comes at the tail end in, for example, the criminal justice system. Coming at the tail end, there is very little you can do. The investigations are done elsewhere, the indictment, the charges are done elsewhere by a constitutional office holder. There's so much prior to alignment in court that becomes almost determinative to how long the process will take. So I will do my very best at NCAJ to say that we must take this country to another level. I would want to get as much cooperation from the other actors, because they are real actors in this system, and without their cooperation, there's nothing that can be done. But the unfortunate thing, Commissioner, says this, that the person who gets the blame from the public is not those other actors, it's the judiciary. And when, for example, and I've done this as an empirical study, when adjournments are also sought by the prosecutors, and they are sought over and over again, a month goes, 6 months goes, a year goes, the person who gets the blame is the judiciary. And those who applied for adjournments do not want to say they caused a delay of 1 year. So it's got to be a collectivity. And the key word here is collectivity of action. And that collectivity will be at NCAJ. But here, at the end of it all, is a question of whether we want to go the Singapore way, which to me is the correct way, or whether we would want to just stay with what we are doing, which to me is the incorrect way. We must have expeditious disposal of cases.
Thank you. If Senior Counsel were to be Chief Justice, you would have, at the very least, 3 very core functions. There are more, but 3 core. But considering the whole 5 or maybe 6, which would Senior Counsel consider to be the most important role, if that is a possibility, of the holder of the office of Chief Justice, and why would that be considered to be the most important role of the office of the Chief Justice?
As I look at the Constitution, my obvious answer would be the first and fundamental role of a Chief Justice is the head of the judiciary. Being the head of the judiciary has its own far-reaching consequences. You therefore become, so to speak, the titular head, not just the titular head, but the real head, the policy head of the entire judiciary. It's by virtue of being that head of the judiciary that you also have the second hat of presiding judge or the president of the Supreme Court. That role of president of the Supreme Court is a role that I have trained myself for. It's a role that can be played or can be assumed by a practitioner of my standing, and the other roles would be the other commissions, this commission being one of them, NCAJ being another one of them, Council of Law Reporting being yet another one of them, and commissioners, I do have that which it takes to be able to have enough time for all those roles.
Which leads me, Senior Counsel, to the next question. And it is the question of balance between the many roles that the Honorable the Chief Justice is required to execute. So how would Chief Justice Ngatia balance between those roles, and what would guide Chief Justice Ngatia in the balancing act between the roles? You have identified that of the head of the judiciary as, to you, the most important one, but that must not make the others suffer. And therefore, what would be the balancing act? Part one. Part two, the Chief Justice, and you've mentioned that, being the President of the Supreme Court, must ensure, in my view, that that court works. Must ensure that as the final court, what comes out of that court is indeed final in nature, so that it really doesn't require explanation and so on and so forth. So balance between the execution of duty of the various roles of the Chief Justice to be able to make yourself an effective Chief Justice?
Thank you, DCJ. As head of judiciary, as I indicated, that's a leadership role. And the beauty with it is that in this judiciary, we have very well established structures, statutory structures, which are very well established. And the Chief Registrar of the Judiciary is the accounting officer. It's not my role to try and micromanage that statutory duty. But I do have an interest to ensure that it's well done. So my first port of call would be the leadership advisory committee, because I would want to carry the entire judiciary or to be with the entire judiciary. I'll regard that as my cabinet. Being my cabinet, I'll be able to know what is going on in the Court of Appeal, in the High Court, and courts of similar jurisdiction. In all probability, we should also have a magistrate with us. The CRJ is with us. Heads of directorates are with us. I would want to have very structured meetings with all of them, because that is the cabinet. And with that cabinet, because I'm still ultimately the one reliable, I should be able to know what is going on at every level of this judiciary, including the Cathy's courts, and including how many tribunals have transited and what we are doing about it, and including the improvements we can make, like small claims courts and how we get them going. So it's not difficult for me, because I have with me a dedicated team that I do hope I'll be able to work with quite effectively.
Thank you, Senior Counsel.
But if I could explain about the Supreme Court, because you had also asked me about the Supreme Court.
Yes, please.
The Supreme Court, being a collegiate court, I'll be one amongst equals. And what I'll do from day one is to personally call all the Supreme Court judges, and we shall have a meeting as equals. Collegiality, commissioners, does not mean, and I must say this, it does not mean that I impose my views on them. it does not mean unanimity in decisions. That's not what collegiality means. And we, as a Chief Justice, I'll try to have very robust engagements by the judges. I'll not stifle them by telling them, look, let's decide this way. Sometimes, in most times, by having individual opinions is the growth of law. But if you stifle it by having unanimity, you are not going very far. But of course, in such certain very divisive topics, like say racial segregation, you'd want to have the entire court with you. But with the ordinary cases that go to the Supreme Court, I would want the individual judges to actually show their best. If I could digress a little, we remember Judge of Appeal Nyarangi, because of his individual opinion in Motoves Aurelian. And we cite this to my Lord every other day about Judge Nyarangi said this, and we all remember him for that. In other words, individual opinions do immortalize judges, particularly if they are well done. I'll be able to balance that work because of my deep desire in development of law. Law is my passion. Instead of other pastimes, I would have time, even in the evening, to read and to generate my opinions. And even in that court, the Supreme Court, I'll try to have the same thing, expeditious disposal of cases.
Thank you very much, Senior Counsel. Let's go to a different area now. You must have come across someone called Montesquieu. You will tell us who that guy is. Tell us what he said, what is he known for, and how does that relate with interdependence?
Very good. That cause for me to quickly remember my reading in philosophy. Up to around 17th century, I may be mistaken, maybe a little earlier, man was living in what can be described as state of nature. A state of nature meaning there was no community or there was no law and order. That state of nature meant you are on your own. Consequently, life was very short, very brutish, very violent. Because of living in that state of nature, although lawyers want to take advantage of this, it is actually philosophers who actually saw a need of moving from the state of nature and to live within a community. And the first, if you could allow me, DCJ, before we go to Montesquieu, the first philosopher who saw the need to move from the state of nature to a community is John Locke. John Locke, or either John Locke or Hobbes, it's John Locke, who actually said that much as we want to go to a community, there are certain rights we cannot surrender. The first right we cannot surrender is life, liberty, and property. But we can surrender other rights of protecting ourselves. We surrender them to this community or this body politic that we shall create. So those three rights which could not be surrendered are today the rights we talk about, which cannot be alienated. But soon after John Locke came Montesquieu. Montesquieu said, even as you move from the state of nature, there's something you are missing. The first thing you are missing is absence of a body that can make laws. Because yes, we are moving now to a society, a community. We have an absence of a body to make laws. Next thing you are missing is an impartial judge. The third thing you are missing is somebody to enforce the laws. So Montesquieu, a French philosopher, is the one who is credited the world over by having the separation of powers. Separation of powers is not a lawyer-driven exercise or initiative. It came from these philosophers of the 17th century. That separation of powers was quickly taken over, as well as the three rights which cannot be surrendered, and the Thomas Jefferson, as you may recall, in his Declaration of Independence, he ran away with it. And in America, the Declaration of Independence, which was done, I think, in 1770-something, had the three rights. Right to life, liberty, but then he twisted, Thomas Jefferson twisted the property, and he said, pursuit of our own happiness. So the Declaration of Independence of America is a direct attribute of those philosophers. I hope I have answered you fully.
Save for we would like you to say something about what Montesquieu said, and which I think you have sufficiently explained, related to interdependence.
Interdependence, the beauty with interdependence, therefore, even at Montesquieu level, you have the three powers, for lack of a better word. One creating the laws, another one the impartial judge, and another, the third one enforcing. And this become the legislature, judiciary, and the executive. Their interdependence is that you, as the executive, you require the laws to be enacted by legislature. And as a judiciary, you become the impartial arbiter of any dispute that will arise, either horizontally or even vertically. And in that, I see, as a matter of fact, that is the same thing that is today known as the separation of powers within our Constitution. The interdependence meaning that you are not isolated. Could I say this? Judiciary is not created for itself. Judiciary is created as a service industry to the people of Kenya. So if it's understood we are service industry for the people of Kenya, we are not created for ourselves, then we become interdependent because the people we are serving are the people of the Republic of Kenya. Both executive, both legislature, and more important, the 47 million or 40-something million of our citizens. That is our core business.
Thank you, Senior Counsel. I have two final questions. And the first one will be as follows. Would you say that the jurisprudence emerging from the Supreme Court confirms the transformative nature of the Constitution, or it belies it? And while still at the Supreme Court, the Supreme Court has exclusive original jurisdiction to hear and determine disputes relating to the elections of the office of the President, arising out of Article 140 of the 2010 Constitution. Please, with the reference to Section 83 of the Elections Act, the various amendments thereto since 2016, and any other relevant jurisprudence that comes to your mind, Senior Counsel, please discuss the role of the Supreme Court in the nullification or confirmation of a presidential election. And please tell us whether that jurisdiction should rest in the Supreme Court, and what the challenges of hearing that important case are to the judiciary as a whole?
DCJ, you put me in a small fix, but I'll navigate. I'll definitely navigate these very difficult areas. The first one is easy. Supreme Court has come up with some very transformative judgments. Very, very transformative. Let me say this. The Murwateto case, although misunderstood and misapplied by courts in Kenya, has won the pride of place all over the world. I do not have, but I can provide to the Chief Registrar. I was just going through my searches around Murwateto. It is quoted with approval in Barbados. A whole paragraph of Murwateto is quoted with approval. Not just Murwateto, but a whole paragraph of how the Supreme Court came to arrive at a decision that a mandatory death penalty is an illegality. But having said so, I think I could say a word or two about it. In Murwateto, which I had occasion to argue, the question was not about death penalty as such. The question was about a colonial relic. In 1938, the colonial masters inserted Section 204 in the Penal Code. They did the same in other colonies, in Malawi, Zambia, Belize, a few other colonies. But at the turn of independence, those other countries had amended their law. But in Kenya, 40, 50 years later, we still have this Section 204. My attack was on a mandatory death penalty, not the question whether a death penalty is constitutionally viable. It could be viable. But a mandatory death penalty means that we are sharing our judicial power with the National Assembly. Judicial power cannot be shared. The unfortunate thing, commissioners, is this. I think Supreme Court didn't make it as explicit as it could that this applies only to Section 204. For the simple reason that Supreme Court thought you can bring into place other actors like Attorney General to come with proposals. Hopefully after they have come with proposals, then Supreme Court will give further directions. As fate would have it in this country, there is a word called lethargy, and after a year, the year that Supreme Court thought that the report would be there was no such report. I lost track with the Murwateto case. But I do know as a fact that what Supreme Court would have wanted to do was not done because the other players in that who are defined by name failed to do that which they were supposed to do. But it's not too late. In the event that you honor me with this position, I'll immediately get to Murwateto, see how the judges who could hear it or to come to terms with how we now do not allow it to be a way of people running away from what are otherwise valid sentences.
Murwateto Senior Counsel is one case. Another one that is transformative?
Another case which would have been transformative but didn't become as transformative as I thought was the arbitration appeals. Because we lost the opportunity of Kenya attracting arbitrations from all over the world like other countries have. That case was going towards making arbitration insular from judicial intervention. The Supreme Court almost reached there but backed out by saying that go back to Supreme Court and let Supreme Court see whether it was. So those are the two that would immediately come to mind. As regards presidential election petitions, could I start off with the challenges? The first challenge every Kenyan would say is the 14 days. It's not a challenge. We have done it 3 times. We have done it because lawyers in this country do believe that you can do tasks within a relatively short period of time. I say this in contradistinction to what happened in Zambia. In Zambia in 2016, they have the same law. The lawyers took 10 days, exchange of papers, another 2 days, case discussions and case conference, and they remembered they have not had their case on the 14th day. So the presidential petition was not heard. It was not heard because they started saying that can there be extension of time? Needless to say, the lawyer for the successful party said it's cast in stone, it's cast in the constitution. So I do not see that as a major problem. Section 83 DCJ in 2013, it was applied fully. It's on the basis of Section 83 that the election was upheld substantially. Come 2017, there were difficulties. The court, the majority decision did not apply, as I remember, Section 83. Dissenting judgment, I believe, of Supreme Court Judge Joki dealt with it. But then there was an amendment by National Assembly. Many things were done. The amendments have been struck off, I remember, by one of the petitions by Katiba Institute. So we are in fairly murky waters about the application of Section 83.
Who should start hearing that case, Senior Counsel?
Sorry?
Which court should?
A presidential petition, I would, without reservation, say, should be the sole preserve of the Supreme Court.
Reasons?
We have a lot of similar jurisdiction. Malawi, as you know, has the similar jurisdiction. They nullified the presidential petition, I think, last year. If we do presidential petition in any other court, then there will be issues about appellate processes. I do believe Supreme Court has won its pride of place by having dealt with 3 presidential petitions, and in all 3, the actors may have had reservations, but by and large, is now an established jurisprudence of the Supreme Court.
Now, to my final question. Right now, as we are sitting here, there is the debate whether or not the 15th Chief Justice of the Republic of Kenya ought to come from inside or from outside, the insider-outsider debate. What is your view of a practitioner, in effect an outsider, at this particular time coming to head this very important institution? Justify your answer with some basis, and that will be my last question to you, Senior Counsel.
Thank you, DCJ. Maybe let me start with the last. United States of America, which has the pride or prides itself as being the most liberal democracy, from 1896 to 1953 had racial segregation as part of its judicial policy. Schools were on racial basis. A black boy, black girl will go to a black school. Similarly, a white girl, white boy will go to another school. Public transport was in the same way. Supreme Court in that country was divided for over 70 years. They had several judges, eminent chief justices, they could not see that segregation is an archaic practice. 1953, General Eisenhower nominated Warren as the Chief Justice. Let's look at Warren. Warren was a very successful lawyer, had conducted numerous prosecutions in the United States of America. He was one of the most brilliant lawyers America had seen. He then transitioned to be the governor of California. Was a governor, I think, for 2 or 3 terms. In 1952, this Warren man was so popular he thought he could stand as a president and sought the nomination of the Republican Party. He was defeated by Eisenhower. He subsequently became the Chief Justice of the United States of America. I emphasize this insider-outsider difference, how difficult it then becomes. Warren is coming from a lawyer who became a governor. He's never held a judicial position, didn't have the longevity of private practice like I've had, and he became the Chief Justice. And then the question came in his court about racial segregation. Brown decision. Warren marshaled all his colleagues and they had a unanimous verdict that there can never be racial segregation in the United States of America. Something that had been unable to be done by chief justices, career judges who had been appointed as chief justices. Same Warren, you remember in the next case, Loving against Virginia, you could not marry across racial barrier. A black boy could not marry a black girl. And Warren came with this very beautiful sentence that love resides in your heart. And no state has the business entering your heart. Unanimous verdict. He managed to defeat racial segregation in the United States of America by his judgments. Look at the first judgment by Warren. This of racial segregation in public schools and transport, 12 pages of brilliance.
All right, Senior Counsel, we have heard about Warren. Now tell us why are you saying the outsider therefore is better than the insider?
No, I'm not saying there's anybody who is better than the other. My point is this: please look at merit. Please let's not have this distinction in JSC as my plea to you that there's anybody who is an outsider, there's anybody who is an insider. The hours I have spent in judiciary before Supreme Court came here, this was our High Court, Honorable Commissioners, this was our High Court. I've spent more hours in the library here, I've spent more hours in court here than cumulatively a few judges have spent in their judicial life. In other words, I do not see it as a correct description to call a practitioner an outsider. I prefer you call him a consumer of judicial service. No, definitely not an outsider. I'm as much part of you, I hope I will not be rejected, as much part of you at all times, because I'm a consumer of your service and I represent the people who actually become the beneficiaries of judicial service.
Thank you very much. Thank you, Chair.
Thank you very much, Senior Counsel. Just a small clarification. I took an interest in your answer by the question from DCJ on this philosopher called, is it Montesquieu?
Montesquieu.
Yes, and you answered very well. You answered very well, giving an academic answer. And my question is, Senior Counsel, is this philosopher someone who, in a lawyer, would remember what they said from their judiciary philosophy class, or is it that you read a lot of philosophy?
Professor, I will say this without any fear. I did a bachelor's degree in law, University of Nairobi, a master's degree in law from possibly the second best university in the United Kingdom. We never learned philosophy. I learned philosophy in Strathmore in my second master's. Philosophy therefore becomes one of the most important tools that you must have, particularly if you're going to any leadership position. Montesquieu and all other philosophers, Thomas Aquinas and everybody from medieval times. And if I could, with your permission, the first trial was of Socrates. And you know, probability, my Attorney General may recall, the first trial in 399 BC was of Socrates in the city of Athens. And those are the things you learn in philosophy. It broadens your knowledge, it broadens your judicial approach, and lastly, it gives you a very complete world view of the law and the people that you are to serve.
No, that's okay. I just took an interest because of the way you answered it, but now...
Thank you, Prof.
I'll now request Honorable Commissioner Mohammed Warsame, Judge, to continue the technical questions.
Thank you, Professor. Senior Counsel, from what you have stated, you are a successful advocate and you have practiced law for quite some time. I want to know and understand what motivated you to apply for the position of CJ and what you are looking for and what values, both in terms of administrative leader, jurisprudential leader, you bring on board.
Thank you, my Lord. Chief Justice before 2010, I would not have been interested. Chief Justice after 2010, I'll be interested. Interested to serve. I emphasize interested to serve for the following reasons. Post 2010, the Chief Justice is really a leader and a transformative leader. A leader who will never take us back to the state of nature that we almost experienced in 2008. A leader to take this country to a level that we can now compete with our equals in the world. What values do I bring? My Lord, I bring the following values. Ethics is one of my core attributes. I'll bring ethical values into this judiciary. Ethics not in terms of saying do and don't, but to inculcate a culture that we know we are there to serve. To inculcate a culture of correct work ethic. Correct work ethic is not something you legislate. It's something you almost, so to speak, fellowship with the fellow judges. And we agree that really let us be servants of the people who have given us this power. This judicial power is derived to us or given to us by the people of Kenya. We are trustees. Let us not abuse that trust. I'll bring all those values. I'll bring the values of hard work. Allow me to say this, my Lord. In this career that you have referred to as successful, it is a career that I have managed because of one word, perseverance. And for any lawyers, wherever they may be, young lawyers particularly, I would want to tell them this. This legal career, if one is starting, you do it brick by brick. There are no instant successes. And equally for the judiciary, I would wish to have discussions with judges at JTI and to see that really by peer review we can even improve our reasoning in judgments and rulings. Those are some of the values that I believe I'll bring.
Thank you
I'll
very
bring
much.
that value of continuous reading of beyond law, philosophy, and other disciplines. Thank you, my Lord.
You have also talked about the impressive CV of Mutunga and Maraga, what they did as Chief Justice. Because of the 2010 Constitution, having served also in the judiciary even before them, I was also very impressed with Evans Gisheru as Chief Justice. That's for your information. JSC is looking for a Chief Justice who can take the judiciary to the next generation after Mutunga, after Maraga. I want you to share with the Commission, from your experience and knowledge, 3 institutional weakness, if any, in the judiciary that you will address so that you can take the judiciary to the next level. 3 institutional weaknesses.
Before I go to the 3, my Lord, Chief Justice Gisheru and other Chief Justices also did beautiful work. I was here when Chief Justice Madan was the Chief Justice Coker. I have worked under them. They did wonderful work under difficult circumstances. But those circumstances are no longer with us. The structural difficulties which were there are no longer there. Some of the, and I say this not as a condemnation, we still have weaknesses in delivery of or conclusion of cases. Conclusion of cases is still bedeviling us in a very major way. Hearing of cases is also something that is still a challenge. ICT, as my Lord is aware, we have done, and I must say this, it is my heart to judiciary. We have overcome the mental barrier. Most of us had a mental barrier that ICT cannot work. We have overcome that barrier. We now know ICT can work. All we need to do is add capacity, and we are almost there. And with ICT, with other human skills, human resources, will be more or less on the way to the next level.
Thank you very much. Now let's go to the difficult issue. This is RILA 2013, which in my view spearheaded a critical legislative reform in the election laws that included the incorporation of technology in our elections. But one of the critics of that decision is what the court called the timely filings of election petitions. And you were involved in this case. The court rejected that voluminous affidavit by the petitioner, which was filed, in my view, within which was not filed within the it was not filed with the petition, but it was filed before the determination or the hearing of the petition. Are you a Chief Justice who will give broader interpretation to filing of petitions, such that if somebody feels he has filed the petition within the 7 days, but there are critical issues which needs to be brought before the court, and it's brought before the determination of the decision, are you a Chief Justice who will allow broader determination, broader interpretation, such that justice is served to all litigants who come before the Supreme Court, especially in presidential petitions?
My Lord, as you indicated, is a difficult question, but we can actually answer this on principles of the Constitution. The first principle, my Lord, is that we have 14 days for Supreme Court to decide. Or let's start a little earlier. from the declaration of the resort, an aggrieved party has 7 days, 7 solid days. Put your act together. So the petitioner has a very big advantage, and I would want to be understood in this very well. Petitioner has 7 days from declaration of resort. A petitioner who is desirous or who considers that if all doesn't work well, I'll be petitioning Supreme Court, has another almost 5 days at Bomas of Kenya, where collation of resorts is taking place. So cumulatively, a petitioner who is diligent has 12 days to put his house together. The respondent has a very short period to answer hundreds and hundreds of volumes of pages. And my Lord, as you indicated, I've had the advantage or I've had the privilege of handling this. It is not once or twice. I had, together with my legal team, less than 2 hours of sleep per day, because you are dealing with massive accusations, massive innuendos, and massive everything. So the respondent actually is disadvantaged. By the time of filing this, you have Supreme Court, per the Constitution, has 14 days. My Lord, let's agree that is cast in stone. It's not elastic. If you are to allow the same petitioner who had 12 days to put his act together to be able to come with another affidavit that would require me another 3 or 4 days to respond, my Lord, you take us to Zambia. We go directly to Zambia, where the judges realized on the 14th day that our time is up and we have not had these characters. It's a dangerous thing. So, my Lord, it's not even a being broader interpretation. It is simply this. Unless there is any amendment, the 14 days is the day that Supreme Court must hear and determine. So you cannot have the luxury of allowing one party more latitude than the other. Allow me to say this, my Lord. If further affidavit was allowed, principles of natural justice, I would have been given corresponding time to respond. If I'm given corresponding time to respond of the 14 days, then we'll start a hearing on the 11th or 12th or 14th day. It's not possible for a hearing to be done.
Okay. Another critique leveled at the court in 2013, the Raila case, is that the court is allowed within 14 days to hear and determine the election petition. But on the 14th day or on the 13th day, the court renders 1 paragraph judgment. In essence, people are saying, and the decision is rendered maybe after 1 month or 2 months, the court is enlarging the constitutional timelines by not rendering the full and the final judgment of the court. Are you a Chief Justice who will ensure judges of the Supreme Court render their judgment on the 14th day or on the 13th day as provided for under the Constitution?
Yes, my Lord, and this depends really from, now I speak as a practitioner, different styles by judges. I've been before quite a few of your brothers and sisters, particularly of yesteryear, who at the conclusion of the case will come up with a decision of the case and say reasons to be provided later. I've had that experience. And I would agree with you, the problem with that is this. I do not know for certainty why the decision went the way it is. I think the middle ground is this. I'll borrow heavily from Warren. You do not need a PhD or a master's as a judgment in any case. In Warren, in the Brown case, it was a 12-page, and it was sufficiently well reasoned to be a judgment. if given the opportunity as a Chief Justice, I would endeavor to my utmost to have a reasoned judgment within the 14 days.
Again, let's come to Raila 2017, Raila 1 2017. The petition was invalidated on the interpretation of Section 83. And the court accorded the section a disjunctive interpretation. Given the use of the word or, and the later after the decision there was an attempt by Parliament to replace the word or with under, which was rejected, as you correctly said, by the Court of Appeal through an application made by Katiba. As a Chief Justice, are you a Chief Justice who, because the Supreme Court is allowed through majority decision to depart from its earlier decision, are you a Chief Justice who will depart from that position because your position that time was the conjunctive interpretation should be given to Section 83? I know it's a difficult, but you have the liberty to answer.
My Lord, you place me in an awkward situation where, probability, the emerging political formations are listening to this. I'll approach that court with a very open mind. Neither conjunctive nor disjunctive. I'll listen to them, oblivious of what my arguments there before were. And there's a lot to be said about this. The minute I take my judicial office, my oath of office, it becomes a divorce, the cut of the umbilical cord between Ngatia practitioner and Ngatia Chief Justice. It is a dicey issue, or has been argued, and I have argued, or can mean as an and it has been argued to the contrary. I'll be a Chief Justice who listen to legal arguments, oblivious of what I may have argued before, and rule in accordance with the Constitution.
Okay, let's come to the simple issues. In your first annual address, the Soja address to the people of Kenya, tell us 3 messages you will convey to the people of Kenya in major areas that you feel the judiciary is lacking or is of concern to you.
I will not approach the people of Kenya with an alarmist statement that the judiciary is lacking anything. My first statement will be that you have a judiciary that is capable and has been delivering very good service. I will be actually a Chief Justice who will tell the people of Kenya, we are here to serve you. But I'll go further and indicate areas that we shall progressively work with them and make this judiciary even more profound in their day-to-day activities. I'll tell them the days of paying cash at the registry are days gone. We do not want so much interface with people. And I'll tell them in 2011, the revenue that we collected is 500 million. Last year, I think it was 2.8 billion. So I'll tell them, let's have more faith in technology. It's much easier for you to pay through an M-Pesa. I'll also tell them that there's this perceived rot in the judiciary, your file is missing. We are going to work together to have a digital filing system, the e-filing system. And I'll tell them that very soon we'll try to have even courthouses to be able to do e-filing for litigants in person. And I will explain to them the beauty with e-filing is that from the comfort of your phone, you can see how your case is progressing. In other words, my Lord, I'll be not a Chief Justice to condemn judiciary. I'll be a Chief Justice to show Kenyans that we are here as their servants and we are going to take the judiciary to the same level if not higher, than what Singapore has achieved.
Thank you. And lastly, Senior Counsel, your solution for the 41 judges. And I wish you well.
Lord, 41 judges, they are now 40 out of attrition. There are many solutions to it. The solution of a discussion would be the best. Failing a discussion, I would do my very, very level best. But my message would be this. I need all hands on deck. Without hands on deck, I will not be able to achieve. So the approach would be, let us find a solution. Let's not deal so much with the legalistic positions, much as they may end up with the result or the other. I would say, I need hands on deck. I am a captain, I'm handicapped, and there are difficult winds ahead, difficult storms ahead. I need all hands on deck.
Thank you, Prof.
Thank you very much, Judge Wasame. Thank you, Senior Counsel. It's now the turn of Honorable Judge Majaja, Commissioner, to continue with the questioning.
Thank you, Chair, and welcome, Senior Counsel. I am looking at your sample writings. You presented 6 of them, some of the cases you have done, and 2 dissertations. And I would praise you that they are very, very well written. But before I touch on some of them, I just want to follow up from where my 2 colleagues have left. Starting with what the acting Chief Justice spoke about, insider, outsider. Kenya has had, the judiciary has been in existence in Kenya for over a century, 1897 up to date. We have never had a woman Chief Justice. So the issue now we are confronted with is to say this position must be for a woman. Just the way there are those who are saying insider, outsider, there are some who are saying now we want a woman to be Chief Justice. So what is your response to that?
As my Lord appreciates, I've never had the honor to be in a decision-making forum like JSC. Notwithstanding, let me go back to what happened not very many years ago, within our lifetime, 1963. Kenya was at the same level with Ghana and with Singapore. Same level. We were at par. Singapore said, we are going to have meritocracy as our guide. Kenya and Ghana did not. Singapore, within our lifetime, is in the first world. We are still in the third world. And our brothers in Ghana, still in the third world. I will not be gender-driven in such an important process such as this. I am not here to say that a lady is not sufficient as a Chief Justice, but I'll look for a leader, be it male or female. I will not, so to speak, discriminate, because by discrimination, I would have even gone against the Constitution. The most merited person, be it a person of disability or whatever, is what I think JSC would go for. And I keep on repeating Singapore because these are things, transformations in that little place that have happened within one lifetime. There's no other country that within one lifetime have moved from third world to first world. And I listened to the Prime Minister, the 5 secrets of Singapore. Secret number 1 is meritocracy. Secret number 1, meritocracy. So here I am to answer you directly, my Lord. If I was looking for a judge, I'll look for judge so and so who fits that description, because it's the legal mind I'm looking for. Be it a lady or a man would be a secondary consideration.
Okay. I note you have also read a lot of philosophy. I haven't. That's why I'm unable to engage with you at that level. But probably tell us one female philosopher, one female person who has done a lot of ethics that you would think has made an important contribution to this area of law we are dealing with.
There are quite a number of lady philosophers. I may not recall them by name, but even at Strathmore, my lecturer, who I think is the head of the department, is a lady. I'll try to remember her name. Gishura, I think.
Okay.
Professor Gishura, a lady. One of the very best philosophers that ever taught me.
Okay, thank you.
Yes.
The other question which arises from what the chair talked to you about, what the chair raised, and what we were talking about, the next generation. In my view, the next generation of this country is the youth. We know, for example, 60%, and maybe I'm wrong, maybe I'm right, 60% will be young people, people under the age of 35. In fact, it is projected that for the next 10, 15 years, we will have a very youthful country. And that presents to the next Chief Justice a huge challenge. Because you have to cut, you said you are a service, you have to cater to that demographic. I was a bit concerned when you say that you use the word ostentatious. There is a word you used that says you are closed, you are not part of social media, that is for other people. But one of the threats judiciaries worldwide and states have identified, and even our Supreme Court has identified, is the whole issue of information and disinformation in this age. Given your position as the Chief Justice, are you the kind of Chief Justice who is willing to engage on that platform that is accessible to what is now the majority of Kenyans?
Thank you, my Lord. Supreme Court of United Kingdom, and I'm sure my Lord will be able to see this during the break. Supreme Court of United Kingdom has possibly the best web page I have ever seen. Supreme Court of United Kingdom. With the click of a button, you are able to see all the outstanding cases, all the cases that have been decided, and actually what the holdings are. It is something we must try to have. It's so educative, so interactive, that you can actually go click to, say, a particular case on Brexit or whatever, and even get the lawyer's arguments in that case. That is the Supreme Court of United Kingdom. We must have that.
What about you as the Chief Justice, head of the judiciary, who people look up to?
I was to go to the next thing. Supreme Court of United Kingdom has a Twitter handle with hundreds of followers. My Lord, as a Chief Justice, I'd have no difficulty with engaging. The engagement I think I was talking about are the engagements that you see which are sometimes, with respect, very abusive, unnecessary, that have become more or less the nature of the day. I belong to a little older culture that when you leave court, you don't start addressing the media about your arguments and everything. I'm of that culture that had a bit of restraint, because if we do not also have restraint, my Lord, then I don't know where we'll be going to. But if you could allow me to just say one word about the youth. I have a message for you, for the youth, particularly the young lawyers. We have hundreds of young lawyers who have no livelihood. Judiciary must change its style. We must also take part in development of this country. My mission or my view would be that we start having innovation hubs in our courts. All we need is a room, have several desks, have Wi-Fi, and these young men and women can be able to do their research. That is one of the messages I would have for the young lawyers. And of course, start over at pilot at maybe Milimani and have it across board.
And finally, just to follow up with what my brother, Commissioner Warsame, spoke about, the 41 judges. And I just want to relate this to an issue of self-sacrifice. Are you willing, if we nominate you to be the Chief Justice, then you are approved by, appointed by the President, approved by the National Assembly, are you willing to tell the President, before you swear me, I would like you to swear the 41 judges? Is that a sacrifice you're willing to make as a prospective Chief Justice?
Judge Majanja, you know, one of the cross-examination is very incisive. I do not think it's possible to have a condition spelled out to the appointing authority. I think it will be disrespectful. But at the same time, I'll make it as important as my swearing in. In other words, my Lord, I do not see it befitting to say you must do this before you do this. But I think in the order of priority is to prioritize both events. To say that, please, as you appoint me the captain, you disable me by not having the hands on deck. That way I think would be more efficient and more effective than going with conditions precedent, as we call them in our court, conditions precedent. Okay. So it's not good to go with conditions precedent.
Yes. Another question, and this is on the Murwatetu. I heard you say that Murwatetu has been applied. Am I correct? You said it has been misapplied.
Misapplied.
Misapplied. Can you tell us the instances it has been misapplied?
It's been applied or misapplied in sexual offenses, robbery with violence, and very many other cases.
And why do you say so?
The Supreme Court was dealing with Section 204. I know judicial officers say by parity of reasoning. By parity of reasoning. Also, by parity of reasoning is a tool lawyers use, is a tool with certain shortfalls, because the parity of reasoning cannot be the same for sexual offenses. Parliament or National Assembly, in my view, is perfectly entitled to say, because of the prevalence of this offense, will give a minimum sentence. And parliaments all over the world have done that.
But you said in your same discussion, the reason why you challenged this law, and again, I'm quoting, you said, your argument leading to the unconstitutionality was that the judiciary cannot share power, judicial power, with the legislature.
Correct.
That is the principle upon which 204 fell to that extent.
Correct.
So what is the difference between sharing power with the judiciary in mandatory death penalty and sharing power with mandatory sexual, and it's not only mandatory sexual offenses, it's Forestry Act, for example. The old woman who is in the forest, she's found with firewood, and she's told she has to go to jail or pay 50,000 shillings. So what is the difference in the is the issue the principle, or the issue the offense? That we can pick and choose the offense, but remain with the principle?
My Lord, there are two different situations here. In murder cases, you have a one sentence fit all. We know as lawyers that no two murders are the same. So to have your life extinguished on conviction of murder, notwithstanding extenuating circumstances, is to have a sentence to fit all circumstances. In other legislations, penal legislations, I am of the view that depending on the prevalence of a particular occurrence, National Assembly may be within their power to indicate, for example, that for this offense, you pay a fine not exceeding this. So it's not a co-sharing of power. What Parliament is saying is that there's so much of prevalence of this issue. But I must also indicate to you, my Lord, that is not something I have ever argued. My arguments were limited to Section 204.
Okay. So I'll just ask now, going back to your readings, which I said are excellent. I have no problem with them, but just to raise a few issues. You were in the Okemo extradition case.
Yes, I was.
And I'm not talking about the merits. This case started in 2011. It started 2011. 2013, a petition was filed in the High Court. 2015, Judge Lenaola gave a judgment. You appealed in 2016. 2018, Court of Appeal gave its decision. That's a period of 7 years. And if it went to the Supreme Court, probably it would take 2 or 3 years. So that must be an issue. If you become the Chief Justice, that would be an issue of concern to you, that an extradition case running through the system would take an average of 7, 8, 9 years. Probably just tell us one intervention you would make to deal with this kind of situation, particularly in this kind of cases where international interests are involved.
My Lord, it's a question of sometimes of a good case management. If judges were to conference, you may be able to actually see that the issue raised is a single issue. Without going to the merits, as you indicated, it's a single issue pending for determination in the Supreme Court, namely between AG and DPP, who has the legal power. It's not something that ought to take years. It's a single issue appeal. And I sometimes make my appeal so easy.
So I'm talking about the process. So what would you do in that situation?
If it started with the correct case management at the High Court, it was the same issue. It didn't require lots and lots of hours to argue. It was a single issue, and Judge Renaora decided it. He was overruled by the Court of Appeal, and we are waiting now for the Apex Court.
Okay. Then we have the Wajir West constituency petition. That one you lost. You lost in the High Court.
I won in the High Court.
You won in the High Court. Sorry, you won in the High Court. The election was set aside. Then you went to the Court of Appeal. The Court of Appeal said you can't bring new issues. Set aside the decision of the High Court. Then the matter came back to the Supreme Court, and the Supreme Court upheld the High Court.
Yes.
There has been a concern, and this concern is reflected in the quote-unquote BBI amendments, that these election petitions should stop at the Court of Appeal. Is that something you agree with?
I speak now as a scholar. Too many petitions end up going to the Supreme Court. And Supreme Court is not being called upon to determine constitutional issues. A lot of them are really contestations of fact. Those contestations of fact, there ought to be a sieving mechanism at the door of the Supreme Court. So the ones which are dealing with contestations of fact, they are told no, be content, live with it, learn to live with the Court of Appeal decision.
So in actual fact, you're saying that this amendment is really unnecessary. You're saying because the Supreme Court has the jurisdiction to say that this election petition, for example, does not raise constitutional issues of constitutional interpretation and application, and that can be the sieve.
Yes, as my Lord will recall, the open door policy was done through Munya.
Munya, yes.
It's Munya.
Yes.
Munya case is the one that opened all the doors.
Yes.
Before Munya, we were in good comfort zone.
Yes.
But after Munya,
your client would actually have lost without Munya.
Yeah,
but on the larger question, so you agree that in fact election petitions ought to be treated like normal litigation?
Correct.
Yes.
Because they are.
Because they are.
Yeah.
So the Supreme Court has the devices to say that, you know, just because an election petition emanates from section whatever of the Constitution, it's a normal case and you have to show us that in fact.
Very, very correct.
Okay. So say, for example, what one of my professor friends used to say, is there a difference between the governor's elections in terms of general public importance and one for an MCA, for example?
Apart from, of course, the ego, the legal questions are the same. Because you are dealing with an electoral process. And dealing with an electoral process, all these must be seen in the same vein.
Okay. Then there is the issue of geochem and geochem, Kenya Bureau of Standards. That's one of the cases that came after Newto and Synergy.
Correct.
Yes, and I'm happy to say that I briefed your senior counsel in Newto just before I was appointed.
Thank you very much, my lord.
One of the critiques of Newto, and this is maybe something you will have to address. One of the critiques of Newto and Synergy is that it actually opened the door to appeals in arbitration cases. How has that affected, in your own view, the general right of appeal in other cases generally?
My lord, because this is something that is important to discuss and to talk about. Newto and Synergy also argued at the same time, and the decisions delivered at the same time. When you have some time, please look at the holdings in both. In Synergy, the final word is go back to Court of Appeal for hearing on merits. That's dispositive, the dispositive part of it. In Newto, which I conducted, it's slightly different. We are told, go back to Court of Appeal, but this guy must establish in limine, making it like a preliminary hearing, whether he was entitled or his appeal lies within Section 35. So that's why you see that Synergy has been processed by Court of Appeal undetermined. Newto has not, because Newto must go through a hearing in limine before it is admitted. So in my respectful submission, a lot of very difficult areas have been within Newto. How will you have this preliminary hearing within a hearing?
And so would you, in your own view, the Chief Justice's dissent would have been a better decision? You shut that door and call it a day.
Well, I won't go as far as that because I'll be saying that to have a partisan interest. But the Chief Justice dissent is very, very powerful. It's a very powerful dissent. And as we have seen in our judicial development, sometimes the dissent becomes the voice after some years.
Okay. Now, you have practiced for many years. And when you practice for many years, you become steeped in the traditions, the arcana of common law. And Justice Willie Mutunga then says that part of our challenge of judicial transformation is common law capture. We are captured by the common law. And for those of you who have practiced, some of us who have written, common law is a beautiful thing, but it is capture. It restrains us from transforming our law, decolonizing. As the Chief Justice and leader of the Supreme Court, what are some of the ideas you have in terms of surmounting the common law capture in order to transform our jurisprudence?
Yes, my lord. The common law capture is because that is what lawyers are taught at first tier system. The first tier being our first interaction with the law faculty. But as we progress, if we progress, we start finding that that capture or that information we got is not really the correct information. I have traveled and I have lawyers I work with. For example, in India, and actually you may be surprised, my lord, we are not very dissimilar. I think it's Article 20, yes, Article 22, which provides that dealing with Bill of Rights, the court should not be restricted by procedural technicalities. Should not be restricted by procedural technicalities. That is in our Constitution. Despite this, you still find, because of that capture you have indicated, courts here still require elaborate pleadings to be made. In India, we have what they call PIL, public interest litigation based on the Constitution. And that litigation can be done as informally as the court itself calling for the minister to appear before them and explain a constitutional infraction. So I am not captured, I am within the development of the Constitution that we must now give way to the modern way of doing things. Okay. And the Constitution has already given us this.
And in fact, in your thesis, this one on legal difficulty of delimiting the Kenya-Sudan boundary, which is now prescient as we are dealing with other boundary issues, maybe you would have been the lead counsel. But the
Attorney General didn't appoint me.
Yeah, but there is a quote here that you know attracted me, and maybe I'll just read it to you and ask you. Say, sociological and geographical considerations are discussed briefly, not because they are unimportant, but they must be regarded as peripheral to legal consideration, which forms the main thesis of this paper. What I wanted just to ask is, apart from the law, are there other phenomena, other considerations that affect the law that are actually relevant in the way you interpret and read the Constitution?
Yes, my lord, as I've indicated in that paper, sociological considerations are so important. As a matter of fact, the Supreme Court Act, Section 3, talks of developing a rich Kenyan jurisprudence. So we much as we look all over the world, our bearing, or if I were to use navigational terms, the beacon for Supreme Court is to try and develop a Kenyan jurisprudence. So sociological considerations become important, anthropology becomes important. We are who we are because of where we have come from. Those are things that we must start interacting with, because just interacting with abstract legal issues, our apex court will not grow.
And in your other dissertation on euthanasia, again, very well done. I've learned a lot from it. And one thing I've realized, it was an empirical study.
Yes.
And you found that, in fact, euthanasia is widespread, but under the table, widespread. And you were trying to ask, why is it being done? This is the same issue with abortion, isn't it?
Correct.
It's widespread, but it's all under the table.
Yes.
So the right to life is provided for in the Constitution. It is there. It is also, and the right to life begins at conception. But one of the interesting things in the Constitution is that that life may be taken away by written law. Written law. So Parliament has the space to legislate when life can be taken away. And it can actually, if it wished, it could permit euthanasia and other forms of how life can be taken away. But what I want to ask you is this. First, if Parliament passes a law, what are the kind of standards, constitutional standards, values, principles, can you discern from the Constitution itself that that law must be judged by to pass the constitutional muster?
Yes, the beginning point is Parliament cannot pass a law which is illegal. Parliament must pass a law that is within the law. And discussing this from the point of the paper that I wrote, allow me to indicate a little bit more. Euthanasia became what it is in the United Kingdom because of a decision by Justice Kennedy in the Planned Parenthood case. I'm sure you're aware of that. In the Planned Parenthood case, Justice Kennedy said that it's within you to decide what you can do with your body. In other words, your body is your self-project. And he used very flowery language to mean a person is like self-regulating and you have every right with your body. And that determination by Justice Kennedy had a direct influence to euthanasia, to abortion, to all the things that subsequently happened. My view is this. Philosophy now comes to regulate our life. Is man a self-project, or is man beyond a self-project? And that is answered in philosophy. If you look at Jeremy Bentham, he considers man to be sovereign. You consider other philosophers, they say no, man is not sovereign, you live within your image. But fortunately for us, we go to our own philosophers. I am who I am because we are.
But you have still not answered my question. My question is, Parliament passes a law. Because this is going to happen. In fact, Parliament may pass a law. There will be people running to your court to say this is unconstitutional. Parliament will not pass a law, but the constitutional, for example, recognizes that there is a right to abortion, and people will still knock at your door. So what are the values? Just tell us what are the values, the principles that guide that line between what you think or what the law or what the constitutional value places on life and what it places on the person. Can you just... That is what
I will be guided by the Constitution, my Lord, because the beauty with it is that it's not so much of a view, but what the Constitution provides. So if Constitution were to say that life begins at this point and life can only be taken away through an act of parliament, then that act must measure to the constitutional master of a valid law. At what instances could that life be taken?
Okay.
Yes.
Finally, you agree with me that you talked about perceptions are important in terms of independence of the judiciary, in terms of accountability. We must deal with perceptions. So I'll ask you what I consider probably a personal questions. You represented His Excellency the President in the petitions that we have had.
Correct.
So obviously there is a public out there who feel that if Fred Ngatia is appointed as Chief Justice, he's very close to the House on the Hill, and that will affect his independence. What do you say about that?
The first part of the analysis was correct. With respect to the second one, you had a conjunctive about being close. Kenyans, I would wish to inform Kenyans and the JSC that I was appointed in 2013 to lead a team for which I'm forever grateful. 2017, I was instructed to do the same. But despite, and this is important, despite acting for the president-elect in 2013, as soon as the brief was over, I went back to my private practice. And that relationship of me acting for the president never continued. That is why, my Lord, you didn't see me in any lineup for conferment or chairmanship or directorship of state corporations. The president had at no time tried to interfere or influence me in any work that I have done. You'd remember, my Lord, as a Kenyan, that not too long ago, actually last year, a cabinet secretary tried to interfere with the election or with the appointment of the vice chancellor of the University of Nairobi. I went pretty heavy on the cabinet secretary, and he conceded his actions were wrongful. In other words, without saying many words, no Kenyan properly informed will see me as being influenced by the president, because during that period of time, I've worked for any Kenyan who has sought my services. I've worked for condemned prisoners, 5,000 of them. I'm actually maybe more popular in a few of those prisons than elsewhere. I've given them a second chance in life. Okay. I am not in any way influenced. And let's not forget this, and this is my last word. 2nd August of next year, 6 o'clock, 2nd Tuesday of August next year, at 6:15, in Kenya, there will be a president-elect. And that president-elect will be any Kenyan other than the president of the Republic of Kenya.
Okay, finally. But the issue here is perception. You've propounded the judicial test, but out there people don't propound the judicial test about knowing what they know. They look at you and they say, this one is like this.
Allow me to...
So, let me ask my question, Senior Counsel. So, having known that there is that perception out there, because it's something you'll have to live with, isn't it? Having known there is that perception out there, tell us, out of that situation, what do you think are the two issues you consider an impediment to the independence of the judiciary arising out of that situation, and how you intend to resolve them? And that will be my last question.
If there is a perception, and that will be maybe subjective, because many people I interact with see me as Ngatia, the lawyer, not Ngatia, the person who did the 2013-2017 petition. In between, I've acted for National Assembly, I've acted for so many other people. What I would do in the event that I'm honored and allowed to serve as the Chief Justice is to be as clear as humanly possible that in this judiciary, just like I think Chief Justice Mutunga did, the judiciary will be independent to the extent that we shall not be being directed by anybody or authority, but we shall be independent, being another arm of government. And if, for example, because of having acted for National Assembly or having acted for the President, that warmth or that relationship is to bring a speedy resolution, then that will be an advantage to the judiciary, in the sense that I'll be doing that which, or unlocking that which hasn't been done, particularly, say, for example, in our budget process. Thank you.
Thank you very much.
Thank you, Chair.
Thank you, Judge Majaja. Thank you, Senior Counsel. Just to follow up, one thing you said, Senior Counsel, in your defense, that this perception may not be right, the perception of being close to the President as a result of representing him. You said that you have not been appointed as state corporation or chairmanship. So are you telling the Commission that those people who get appointed is because they are close to the President? I thought it's because of the work they do for the public.
No, I think, Prof, sometimes interpretations can go to any level. All I wanted to explain is this, that as soon as I finished my brief, I went back to my private practice, and that is where I came from this morning. I didn't come from any other place. All I wanted to also emphasize is, as much as I'm a Kenyan, please judge me on that basis. Do not discriminate me because of any client that I have acted for, because in the career I've had, I've acted for the high, I've acted for the poor, I've even acted for those who are in terminal condition. Judge me across board. One of the institutions I work for passionately is the hospice. In the hospice, we have terminal patients. I work for them. They are my brothers and sisters. So judge me for who I am. Do not isolate one person and discriminate me because of that. The President, like any other Kenyan, was entitled to legal representation. I'm not ashamed for acting for him. Actually, as I indicated, it was a big privilege and a mark of faith and trust that he could entrust such a massive undertaking on me. Particularly in 2013, we were navigating uncharted waters. And I did that navigation and did it successfully.
Thank you, Senior Counsel. Honorable Commissioners, we'll take a break now. Mr. Ngatia will take a break for 10 minutes. We'll come back. Welcome back. Honorable Commissioners, welcome back. Senior Counsel Ngatia. To now request Commissioner Macharia Njero to ask his questions.
Okay. Welcome again, Senior Counsel. Of course, for me, I have serious difficulties putting you on the carpet, knowing that I've also known you for a long time, and you've trained most of us, including me, in litigation and all those other issues. But I'll still ask you nevertheless, because I represent the Law Society, and I'm duty bound to still ask you questions. Now, let's start with the jurisprudence, which, as my colleague Justice Majanja said, you've presented very well written papers. But just a question regarding this Murwateto, because following on what some of the candidates here have talked about the matter, of course your responsibility was as a High Court, but when it came now to resentencing, some parties were, lawyers were moving now to the magistrate's court. There were matters that were already in the Court of Appeal. Then again, even when the Court of Appeal was ready now to hear the matters, they would be told that the convicted person have already been released. So a lot of confusion. In fact, some have said that it has led to more, whereas the principle was good, but in terms of now the application, there has been a lot of confusion. So which leads me to the question, as the leader of jurisprudence and the president of the Supreme Court, if you became now one, what would you do differently in ensuring that a decision is well crafted in a way that it is not left to different interpretations? When it comes to implementation, it's seamless.
So the judiciary to have a draft judgment, look at it again, so that it is not capable of judicial or lawyers' ingenuities. Because lawyers' ingenuity is the biggest problem. The Supreme Court was quite clear. What ought to happen is that all the 5,000 of my clients to have a resentencing done by the trial court. And the trial court for murder is only one, is High Court. So the lawyer who went to the magistrate's court actually was doing what we are now talking of, the legal lawyers' ingenuities. So not much blame can be really at the doorstep of the Supreme Court. They came up with a fantastic decision, but in retrospect, it can be perfected. It is not too late. If the Attorney General, I think the Attorney General has already submitted what he was supposed to submit, plus other stakeholders, I think ODPP as well. Supreme Court should now get together and have an order of directions to now more or less perfect their judgment. It's not too late.
Yeah.
But the simple answer is a judiciary, is a Ngatia court, like the Warren Court in America. I would go an extra mile to read a judgment. Sometimes we give the first draft and we publish that as a judgment. Even for my pleadings, I'll have a first draft. Reflect on it, have a second draft. And most of the pleadings have done well. It's actually the third draft, not even the second draft.
Yeah, in fact, the ones who have gone to magistrates, they've applied the same parity of reasoning as you said, even in respect to other offenses.
Yes.
Now, then the Weber case, which again has caused a lot of problems, including even what has been discussed here by some of the candidates, that good decision, but it did not provide clarity what happens to the cases already filed. And so, and there are many of them that had been instituted. The constituency you're referring to that I represent, many of them also even help litigants. They put in resources to file some of these cases, which they agree with clients, they will be compensated after the conclusion. Now the cases are stuck. The Supreme Court has said that, it's the director to deal with them, but without clarifying which, the cutoff and all that. So, again, I don't know what is your view regarding that confusion. Again, whether again the Supreme Court should have gone further to put clarity so that, again, that confusion does not arise.
Commissioner, the Weber case, I must disclose, I was the originator of it. I was instructed by the Law Society, as one of the things I've done for the Law Society, to nullify sections of that act. I appeared before Justice Ojuang, as he then was in the High Court. And he agreed that it had a lot of difficulties. As fate would have it, by the time it went to Supreme Court, I think I was out of the country, and another counsel was engaged. I have difficulties with the judgment, but maybe those difficulties arose because of the transition between counsel. But it's never too late.
Yeah.
Supreme Court is not bound by its decision, and at the earliest opportunity, Supreme Court, I'm sure, will look at it and bring clarity to the law.
Yeah, I see this because it has, it's one of the biggest matters that has caused a lot of pain and anguish amongst, the lawyers.
Correct.
But the lawyers, I must say, were specific that they would want to hear your view
Yes.
regarding that.
Yes.
If you are to become, our Chief Justice. But I hear you.
Yes, and they'll remember that I was there for them at the
Yes,
hour of
yes,
need.
yes,
Because at the hour of need, all lawyers who do accident claims,
Yeah.
their practices had collapsed.
Absolutely.
So even getting interim orders from the High Court was a very big relief
Yeah, absolutely.
to the members that you represent.
Now, let me come now straight to the issue again of, to pursue that issue of perception again, which has been raised by international, by ICJ, right? ICJ, they've raised this specifically, then I'm sure you are aware, you've seen what they've written.
Yes.
And they have been keen, to hear your view on that, and also this Athletes Society of Kenya, so that you can be able to satisfy. And one of the things that JSC did also was to put everybody's, apart from sample writings, also their biodata, everything, so that to be transparent. And now, and they say that they would want to hear to have assurance regarding this issue of perception, because they believe that like some of them quoted the fact that even your church was commending you for bringing the president and the deputy president for a fundraiser in 2018. So they believe that you are quite close to the system, so I mean to the president specifically and the deputy president. So I would still want to hear, and that's my last issue on that issue of perception, how you'll be able to deal with it vis-a-vis the issue of judicial independence, so that, if JSC was to appoint, was to recommend you as the next Chief Justice, that Kenyans will not say that JSC had already decided anyway. It was just, in social media, for us in social media, you will find many of them saying that everything else you are doing is just, window dressing. The decision has already been made. In fact, there's even a joke that if you want to see the next, if you want to know who the next Chief Justice, scratch the card. Then they put your picture and they put, it's like it's predetermined, regardless of the merit and all that. So, as a last point, from where I sit, how do you deal with that perception, considering the fact that you are the chief agent of the presidential elections, which is not wrong. We are appointed in different capacities as lawyers, so one cannot fault for that. But we can't run away from the issue of the perception, and as JSC, we can't again run away from it because we are accountable to the public.
Correct.
Whatever decision we make, we must be able to stand and justify, that position. So I don't know what's your take regarding that.
Yes, I think, Commissioner, it's important I say this as clearly as I can. 2013, a great mark of honor, a great mark of trust to be entrusted with the petition. Together, of course, as you remember, I was a team leader. I had quite a number of advocates that I was working with. Let me say this, it was a one-off. In other words, after we finalized our work, I never continued working for HE, the president, in any other activity, personal or official, at all. And that ought to be put in the public domain as loudly and as clearly as possible. I was never a part or a member of Jubilee Party. Not that I have anything against the party, but because I prefer to be really a lawyer for everybody across the board. 2017, the same thing. It was a one-off. Regrettably, or as fate would have it, let me use the correct phraseology, as fate would have it, despite my walking into that court thinking this time, I'm very comfortable, the voter margin difference is 1.7 million, it was nullified. So I was engaged once again. One-off. And even after 2017, I retreated back to my private practice where I have continued working. I would wish and to emphasize to JSC and the Kenyan people that I'm here as a candidate of the people of Kenya. I am their candidate, and if given the honor to serve them, I will be appearing, so to speak, for the people of Kenya. Not segments of those people. I'll be appearing for the people of Kenya and I'll be implementing the Constitution. Commissioner, allow me to say this. It is correct. I do a lot of work for the Catholic Church. I'm a practicing Catholic. It is correct that indeed we are putting up a very big structure in honor of the founder of Consolata Missionaries. Professor Consolata Missionaries was founded by Blessed Aramano. Blessed Aramano, or his order, came to Kenya in 1902. Throughout the world, there is no country, and Consolata Missionaries are in very many parts of the world, where there is a building in honor of Blessed Aramano. But in Consolata Shrine, I, together with like-minded people, decided to have an office block in honor of Aramano. It's a big thing, and we regard we are the first in the world. The construction cost is quite substantial. We raised it, but we are almost going on our knees. We decided to have a major harambe for all the people of Kenya, not for segments of the people in Kenya. So the first person I actually approached is our MP, Mheshimiwa Wanyonyi. And Mheshimiwa Wanyonyi actually came to church to say he will be part of us. It is also true, HE, being a Catholic, we invited him. It is also true that the deputy president, as the deputy to the president, we invited him. And we didn't just invite political leadership. We invited each and every person, mostly of the Catholic faith, but we also invited my friends who are of the Muslim faith and very many other people. So in that congregation, political leaders were in the minority. The majority were people from everywhere, including one of the outreach is deep sea. Kenyans will call it a slum. I don't know why we use such terms. It's one of the areas we have in Westlands. Each one of them had turned out in large numbers, and we raised a lot of money. I'm saying this to emphasize one simple point. It is a mark of honor for a president to give a citizen, particularly a citizen who is not part of the government, some work to do. But it cannot be used against that citizen for any advancement in the career. And I say this with tremendous respect. If the president approached you as a medical doctor and you did a procedure for him, other patients will still see you as Dr. Macharia, not as the president's doctor, because you are not.
Yeah. Well, for me, I wouldn't mind to be his lawyer. I don't want to lie. If he approached me as his lawyer, not now as JC member, but before, I would happily do the work. Now, let me come now to your individual qualities. We just forget about these other issues. Singapore actually is a case that I admire, and I've also studied the Singapore experience a lot as relates to judiciary. I keep quoting it to my colleagues at the commission to a point almost where I bore them about it. And I agree, it's a classic example where they had a huge backlog and then it was sorted out. But I want to relate it now with just to again test a little bit, because what I noted is that the Chief Justice who changed was Yung Pang Hao. And this guy was for a long time a CEO of one of the most successful banks. In fact, he also helped in setting up the investment corporation of Singapore. He was really renowned for that. And the judges themselves, 4 senior judges in Singapore judiciary, said that our problems are too big, we need an outsider. They agreed, we need an outsider. Just, like yourself. The only difference, and that I'm saying this because it's something that I put through to one of the candidates here, The only difference that they agreed that he needs a bit of judicial experience, and so the route they used was to put him first as a Supreme Court judge for a year actually, then became the Chief Justice. So which brings me now to the question, how you would relate that with you. If somebody said that, yes, because you are actually a jurisprudent, you are a walking, everybody agrees, nobody will argue with the fact that if you're talking about jurisprudence, it is in your head, you are walking jurisprudence. But perhaps the best route would be Supreme Court first, then the Chief Justice to get the judicial experience because of the dynamics of the institution. I don't know what would be your response to that.
Commissioner, it could be said that of Singapore. It's not a rule of universal application. Let's look at my first employer, if we could, because it's a gentleman who made me who I am. From the time he left law school, and I think he was trained in America, then came here, did his bar exams, he was a prosecutor. He was a prosecutor for numerous years. When Charles Jonjo became the Minister for Justice and Constitutional Affairs, my boss was appointed the Attorney General. He didn't go through any formative training. And because of the leadership skills I referred to, he ended up being a fantastic Attorney General. So I don't think you require some incubation before you are given a role. And the same would hold true for Chief Justice Mutunga. And many other Chief Justices we've had in Kenya didn't have to go through some training period. I would say, without any fear, without any equivocation, that I have the tools, the ability, and most important, the zeal to transform the judiciary. I don't need to go through any other position, and that is why I didn't apply for the position of judge of the Supreme Court. Okay. If given an opportunity, just like my two predecessors, within 4 years, I should be able to come before you and come with my scorecard.
Now, again, Al Warren, who again I also respect, that's something we share. And I've also studied a little bit about his background, and which probably could also have influenced his success. But what I also noted is that, as you rightly said, between 1943, I think, up to 1953, that's when he was the governor of California. And California is slightly smaller than Kenya in terms of geographical spread, because I think they're about 423,000 square kilometers. Kenya is about 580,000 square kilometers. So he was actually governing a country, so to speak, equivalent of Kenya. So would somebody probably say that by virtue of being a governor, where he's leading, he's in charge of a state, even in terms of the judicial processes in the state, the administrative processes, legislative processes. So he's garnering experience that goes outside, beyond being an advocate or a lawyer, so to speak, that could probably have also influenced his success, that somebody maybe will criticize and say that perhaps he was better placed because of that background, that experience that goes beyond just being a lawyer, and that prepared him for being a Chief Justice. I don't know again how to be your answer, then I can leave that point.
Correct, Commissioner. Warren is a combination of many factors. He was a fantastic lawyer, went to become a governor, and then ended up as a Chief Justice. The candidate you're interviewing is not very different. I've just explained to you one of the things I did for University of Nairobi. And I didn't need to go to court to be able to transform that college to what it is today. And I've done many of such activities. Warren was in office as a governor, and what all these experiences give us is give us the experience to be outside what you do. If you just say, for example, using, and it's a poor example, you are sitting somewhere adjudicating day in, adjudicating day out, as you do in your chambers as an arbitrator, as compared to somebody with a better world view of beyond arbitration, who has the skills of the arbitrator, but has more than the arbitrator. That is what this candidate who is before you has. I am qualified as a lawyer, I'm qualified as a philosopher, I'm qualified as a leader. I am no different from Warren. I hope I am within near reach of my former teacher, Chief Justice Mutunga.
Okay. Then the other issue that I probably would want to hear from you, and I'm again picking it from the candidates who are here. Kenyans have been seeing the candidates. I'm sure even now they are watching you, you know, and also they'll pick, you know, a few points and all that. And now it seems like some of them are also now asking, particularly now again the constituents that I represent, that you see, one of the most difficult periods for this country was the late 80s and early 90s, before the repealing of Section 2A of the Constitution, so the so-called second liberation. And you know, many of us, for me, that's the time I was just coming from a university. It was a time when advocates, you know, were out there, you know, playing. In fact, I would say that time it's like the lawyers were the opposition. They were the ones who were advancing the human rights, bringing political change, you know, and all that. So some would want to know that during that time, what role you played, in whatever way. It doesn't have to be even at the front, because people play different roles with the same objective and they realize the same results. It's the different parts that lead to the sum total that leads now to the change. That any role that you'd have played in terms of advancing the cause of the second liberation and bringing us to where we are today. Because as you can imagine, one of the qualities you're looking for in a Chief Justice is courage. You know, I'm asking that in the context of courage. Somebody would be able to be out there and to advance the change.
Like-minded people decided to have an office block in honor of Alamano. It's a big thing, and we are the first in the world. The construction cost is quite substantial. We raised it, but we are almost going on our knees. We decided to have a major harambe for all the people of Kenya, not for segments of the people in Kenya. So the first person I actually approached is our MP and completed. And if we were to do those, plus of course, enhancing our IT capability, I assure you, Commissioner, within a short while, we will do what Singapore did. Because we are not inventing a new wheel. We don't even need to go to Singapore for benchmarking. We can see their statistics and their approaches, and day after my swearing in, we start rolling off.
Now my last question is regarding accountability. Because human beings, they want responsibilities, but they don't want to be held to account. In fact, it's something I experienced when I was oversighting police, where the police would say that, you know, you are interfering too much with our work. They do not want to be held to account. They just want the responsibility, no accountability. Now, again, judicial office, sometimes you'll hear some saying that we do not want, you're pushing us too hard. Give us the resources, give us the facilities, let us do the work, but you're pushing us too hard when it comes to issues of complaints. So now tell me, as our Chief Justice, what steps would you take to ensure that even as the resources, you're talking about resources, we are talking about facilitating the judicial officers, the judges, and of course even the judicial staff, that we are also able to hold them to account on behalf of the public, because public also, the complaints come from the public. They also want the institution to be held to account because it serves them. So would you also give us some kind of, very briefly tell us how you go about ensuring that you are also holding the people below you to account? In fact, starting from yourself as the Chief Justice, and then also the people who are below you, so that you are given that position, but you're also able to account to the public.
Commissioner, let me again cite a Chief Justice I'm starting to read quite a lot about, the South African Chief Justice. What he did, because in their JSC Act, equal to ours, it had certain lacunas, like what happens to delayed judgments. And he came up with what I think is a very innovative thing. He came with a practice note, or the equivalent of a practice note, to say that if a judgment is delayed more than 6 months, that is a reportable occurrence to JSC. It's reportable. Why am I going there? We are also coming from a culture where, as you know from your members, members complain of judgments being delayed for 5 years. That cannot be within the work ethic of the modern judiciary. With the tools that I proposed, I would propose that made available, if we have a case management system, and I saw this in the Arusha court, as soon as the court starts, the president of the court can be able to tell the court started at this time. So even the time you start your court, however far off you are, it is a reportable event. That way, you are able now to hold all judicial officers to account, that we are not just sitting back and saying we have independence, and the equivalent of the independence we have in mind is to do nothing, because that is not independence. Independence means or comes with responsibility. And that will not only be the judicial officers, it will also apply to the Supreme Court. We must also be accountable.
Okay. That's all. Thank you.
Thank you.
Thank you very much, Commissioner Jero. Thank you, Senior Counsel. I will now request the Attorney General to ask you questions.
Thank you very much, Madam Chair. Senior Counsel, good afternoon.
Good afternoon, Attorney General.
Just to follow up from the questions that have been posed to you, you're coming to a judiciary where, in the case of the Supreme Court, you have very experienced judges there, and that cuts across the board in the other superior courts, the magistracy, the qadis, and indeed the judiciary staff. And you have conceded, Senior Counsel, that you do not and have had no judicial experience. But you come to this interview with considerable and an illustrious career as a practitioner at the bar. How are you going to bridge this seeming gap of your lack of experience as a judicial officer, where you are expected to lead from the front, to give jurisprudential and administrative leadership to the judiciary, to the courts, and to the other people that you'll be dealing with, like the NCAJ and so on?
Attorney General, I do not see that absence at being a judicial officer as a gap in my CV. I don't see it.
Mm-hmm.
Just like I don't see it, the fact that you are never a state counsel with us, and you being the Attorney General. I see leadership as the pivotal angle. I see in the Supreme Court, for example, judges who were never judicial officers. They became judicial officers when they became appointed judges of the Supreme Court. And they had no difficulty. And for them and for you, sir, you've been exemplary in your service delivery in your respective offices. The fact that I haven't been a judicial officer, but I've had a long exposure in law, and as you say, an illustrious career in law, I see, number one, I'll be easily accepted by the judges of the Supreme Court. I will actually be able to hold conferences with them from day one. I see myself being able to have a very collegial discussion with them. I have participated in most of their landmark decisions. They have, I know, some respect for me. For me, I have tremendous respect for them. So, number one, Attorney General, I see an immediate acceptance by judicial officers. And because of the way I have treated staff of the judiciary, I see no problem between the interface of I from private practice to be the Chief Justice. In other words, Attorney General, I see it as a very big plus. If I had been here and maybe quarreled in the nature of business with a judge, with so and so, that could even be a bigger concern. But because I've never been working here, I am, so to speak, a friend of all and acceptable by all. And with that, I say, without any fear, I see an immediate acceptance at the Supreme Court.
What tools are you going to engage in that leadership role? In formulating your leadership style, what tools, what personal attributes are most important?
As I indicated, I would have prudential judgment, very, very prudential judgment. I'll learn where necessary. I'll have my cabinet, the Judiciary Advisory Council. I'll learn as quickly as I can. I'll be able to work with them. And to a large extent, I will be able to have very irregular meetings with all of them and not change for the sake of changing. Try to work with the people that I find in office because they are my first point of call. And with the people in office would be really the way that I start my first, say, 100 days as I learn. Remembering at all times, Attorney General, that the buck stops at me. In Supreme Court, my leadership style will be very different, will not be any more different. I would want to understand the case backlog. I would want to understand how cases are, how benches are constituted, and then how we can start having our pre-hearing conferences immediately. Pre-hearing conferences, identify the issues, and get going. And in all those, I don't see any handicap. In all probability, I'll be the first to generate an opinion.
Thank you, Senior Counsel. You've just mentioned again the aspect of the expeditious disposal of cases. In the context of ongoing cases, not cases which have not been commenced. And my mind goes back to a case you will remember well because you were in it, of Goldenberg. You represented one of the accused persons.
Yes, I did.
And in that case, it was in the courts until virtually all the accused persons died. And even as we sit here, no judgment has ever been rendered. How will you deal with that aspect of the judiciary's current workload of cases which are stuck, part heards? You mentioned earlier, when we were discussing the NCJ, and how you would bring them on board, you use the word lethargy. And you're referring to the various players within the NCJ. How are you going to deal with that problem?
Attorney General, I don't know how far I can talk about this, but I think I'll be as guided as I can. You remember in the Goldenberg case, I once told the Chief Magistrate, let her remain nameless, that I think the prosecution strategy is to outlive all of us. And I made a pledge, they will not outlive me. This is because I think the prosecution strategy was never to conclude the case. So at NCAJ, because it's all closed door, I'll be able to discuss with the other players that if you're doing a case for only a PR exercise, look for another forum other than my judiciary. You see, there are cases that are made never to be heard. Can I say this without overdoing it? If you are to have 50 accused persons on 120 charges, each of the accused with one lawyer, that is not a case that is going to be concluded within the lifetime of an individual. But you can still achieve the success by breaking it down. Those are the kind of things, very frank discussions, as a Chief Justice that I'll have. Let's not use judiciary for PR exercises. Use judiciary services when you want a case heard and concluded. And for a case to be heard and concluded, our doors are open. And it's not for us to decide for them how to do their work. It is their constitutional right. But it's equally our constitutional right to say, please do not use us as the doormat so that you say judiciary is the one to blame. As you very rightly say, Goldenberg now is every accused person has died, and they died with that tag of having been accused persons. I shed tears when the last accused person died, because in all probability, there was no criminal culpability on the person that I have in mind.
Thank you, Senior Counsel. In the context of Article 160, how independent is the judiciary in your view, Senior Counsel?
Judiciary, and here I think we need to distinguish current and past. Past, I doubt whether it would have been said to be independent as an institution.
Let's deal with the current.
Current, I would say judiciary is very independent. I emphasize the word very independent because judiciary needs to do a little bit more. Is to show that independence, not just the decisional independence, but institutional independence. And Attorney General, let me quote this, let me say this. You see, the more our affairs are made public, the more that people see the case is being decided on merit, the more that somebody says that on their phone they can be able to see the progress of the case, the more we shall actually have 100% rating is very independent. I'll say this. The best antiseptic is sunshine. Sunshine becomes the best antiseptic. Let's open our affairs to the public, and that sunshine will actually show how independent we are. We are almost at the verge. Let's do the next 1 mile, and everybody will see this is a very independent judiciary. For the decisional independence, I think that is something that I cannot comment. I'll need to do a bit of empirical analysis, do a bit of review before I say what rating we are at. But I'll say, even for decisional independence, by and large, practitioners, and here I think Commissioner may agree with me, by and large, practitioners feel that the judiciary of today is very, very independent.
So, in that vein, Senior Counsel, as Chief Justice, as the President of the Supreme Court, and as Chair of the Judicial Service Commission, what would you do to bring about what you call fairly independent into the sunshine you have just described? What steps would you take?
Yes, I'll open judiciary to the sunshine, and the sunshine will come.
How will you?
Number one, we have better IT capacity, better case management systems. No files are disappearing because now they are digital. In South Africa, they have the files, the storage in court and another off-site, so that at no time would anything be said to be missing. And those are the steps, amongst others, that will bring the sunshine into the judiciary. We are just on the verge of that transition.
Thank you. Now, you've been in the corridors of the courts for 40 years. And if anybody can tell us whether there is corruption in the judiciary, it would have to be you, Senior Counsel. How would you respond to that?
It can't be only me, Attorney General. The talk about corruption in the judiciary is at two levels. There's corruption at registry level, which to me is very insidious because it's there and you cannot see it. You know, Attorney General is a former practitioner as well, that will pay court fees and be given a receipt, only to realize that that was a dummy receipt. That money never went to judiciary. So one way of getting rid of that is using e-filing. By e-filing, you eliminate that type of corruption completely. And that, I think, has substantially been done. But having done that, you need audit system, periodic audit systems, so that there is no enterprising Kenyans getting into that sum of money. Then you come to the judicial officers. That is an area, that is the area that I think I would want to deal with as efficiently as possible. We do this really through a process of trying to inculcate ethical values, ethical virtues, and the more we do this, the more we'll get out of any perception of corruption. But needless to say, if there is any obvious case of corruption, not just obvious, if there is any case of corruption, we take it up as JSC.
But Senior Counsel, you're well aware, even when Chief Justice Emeritus William Otunga came on board, he worked very, very hard to deal with the issue of corruption even at the individual level. There have been commissions which have worked tirelessly and rendered reports and recommendations, and you are aware of them. The Judiciary Training Institute has offered training even on the ethical values that you speak about. How are you going to overcome this almost resistance that seems to be embedded within the judiciary?
The more we use the tools that I'm proposing, where you can see that a judicial officer went to court on this date at this time, did this case, and this is his decision. You are able to look at that decision with the necessary parameters and see whether it's within the law. That is one approach. The other approach is we can never give up on trying to inculcate the correct work ethics. Because the minute we start giving up, it is to give up on our own selves. So I'll still do as much as I can to try and inculcate the correct approaches to life, because it's those approaches that will bring us collective victory and collective success. So much as I know of all the efforts which have been done, including the commission you headed, Attorney General, including the interventions you had at the Court of Appeal, I will still not give up. I will soldier on, because this is a battle that must be won. Corruption cannot reign in judiciary. Corruption is a battle that must be conquered by the deliberate effort and the purposeful effort of the Chief Justice and the other members of the judiciary who the Chief Justice will be working with. It's not a one-man show, it is a collective effort.
Thank you. You spoke about the interdependence of the three arms of government. Would you consider the judiciary to be a threat to the other two arms of government?
Threat it could be, just like the other two arms could be a threat to judiciary. You can be a threat if you do not understand your constitutional mandate. If you understand your constitutional mandate, you cannot be a threat to the other arms of government. That is why, for example, it's a well-developed principle, which I would wish to even talk about at JTI, about judicial restraint. It's not benevolence you are looking for. It is an understanding that judiciary does not exist for itself. Judiciary exists for the people of Kenya. Approaching it from that principle, I do not see anybody not being unable to have a dialogue, because I am not doing this for self, but I'm doing it for the people of Kenya. Understood in that context, and since all the persons that we are talking about are, number one, patriots of the highest order, leaders of the highest order, I should be able to have a structured meeting with the three arms of government at any time. And I repeat once again, it's not benevolence, as Adam Smith in this book of Wealth of Nations says, but something for the common good of the people of Kenya.
I'm grateful, Senior Counsel, for having answered those questions, and would have no more. Thank you very much. Thank you.
Thank you, Attorney General.
Thank you very much, Madam Chair.
Thank you very much, Honorable Attorney General. I will now request Commissioner Patrick Gishohi to ask his questions.
Thank you, Professor. Counsel, good afternoon.
Good afternoon, Commissioner.
Very good. I want us to focus on something different. You have spoken very eloquently about the judiciary, the Court of Appeal, the Supreme Court, and all those issues. I want us to focus in one key areas as you come in, if you get this position, and I pray you get it, as the chairperson of the commission. And I want us to remain on the commission itself.
This commission.
This commission. As soon as you get to the office, the first thing that you'll be able to get is a report by the consultants that was submitted to this commission, I think in 2019. In that report, it's about the review of the organization in terms of its operations. We are at the stage of implementation. As a chairperson of the commission, they have raised two issues that I would wish you to reflect on. One, governance efficiency of the commission is below average. Efficiency of the governance structure of the commission is below average. Two, weak performance management system, among others. That report will be on your desk if you get this position. Will you share with this commission how you address those two issues that are very prominent in that report by the consultants?
Commissioner, not being privy to what led to such low grades, because these are very low grades, not being privy to what happened for you to be below 50%, I may be a little hard-pressed to say what prescription I'll come up with. But I can say this. As a Chief Justice,
Chairman of the Commission,
and Chairman of the Commission, I will not only look at the report, because the report is the end product of a process. I will start off with where did we start doing things the wrong way. Because to have a grade that we are below average is an embarrassment to all of us. But there may be concerns and interventions that were not done at the right time. So I would want to see why didn't we do those interventions early enough? Why is our performance weak? I would want to see as many of those reasons as possible. And again, working with this commission, instead of us now saying how awful we have been rated, I will actually roll up my sleeves and say, look, ladies and gentlemen, we must get to over 90% at the next assessment.
Honorable Counsel, that's what I'm looking for. The instruments that you are going to put in place to take us to that level, as our leader, as a commission, as the chair of the commission, if you can be able to share with us one or two issues that you do to take us to that level of 90%.
That's what I indicated. I would want to know why we went to that low level first. That's the first port of call.
Yeah.
Because when you get a result, Commissioner, a result that is 40%, you may not be able to prescribe what is wrong without understanding what led to the 40%.
Okay.
So the first tool I'll look at is our history. When was the last assessment done? What has happened in the intervening period? And what is it that we didn't do correctly?
Okay.
Yes.
I think, Senior Counsel, what my colleague is looking for is a hypothetical indicators. You know, I mean, if you are to assess, in your opinion, what would be assessed, even if it's hypothetical, you must have an idea of what would be assessed.
I see. I'll look at the leadership.
Leadership?
Leadership would be one of the things that I'll look at. I'll look at the collectivity. By collectivity, I mean what are the other members' input or lack of input into that leadership. I'll look at the implementation. Those are some of the things that I'll be looking for.
Okay. I'm sure you have looked at the kind of structure you have the commission. And you're talking about the mechanism of making sure that the commission is accountable. Yeah, earlier on, you talked about accountability in terms of the members, in terms of the staff. I would like to hear from you, what mechanism will you put in place to ensure that the commission remains accountable in terms of the structures?
I'll put every measure in place. I will, number one, look at the regularity of the meetings, the agendas set out in the for the meetings, the way we transact our business, and more important, Commissioner, as you know, it is also the follow-up and the implementation of the decisions.
Okay.
So that if you have a weakness at any one of those levels, then you are not able to fulfill your constitutional mandate, which is set out in Article 160. It is 171. You know, you have a constitutional obligation.
Okay.
Yes.
Let's take the case of the staff, and you have to ensure that your staff remains motivated, productive, and efficient. We have human resource manual. We have policies that govern human resources. I would like to hear from you, as the chairperson of the commission, what programs you put in place to ensure that the staff are productive, efficient, and their performance measured?
Yes. One of the things I think in every large organization, not large, it's all organizations, is a bit, you've got to look at staff welfare.
The staff welfare, yes.
And there are certain very quick wins that you could have with staff welfare. Look at a medical scheme, for example.
It's in place.
Medical scheme for staff is one of the things that is very endearing, particularly when you have staff who are young, of childbearing age, and with young families. That becomes almost a must-do, because you reduce the stresses associated with taking a child to hospital and then the money required. If we can have a staff medical scheme and make sure that at all times it's valid.
Okay. Talk a little bit about reward and sanctions as far as human resources is concerned in terms of the judiciary.
Yes.
Yes.
Reward
and sanctions.
Yes. Reward is something that is very nice and has been tested in a few blue chip companies, where you can have performance indicators. If you go beyond this performance level or you achieve this, there will be a reward. And it's something that people look forward to. And a lot of blue chip companies all over the world have reward schemes, and of course they have sanctions. Because you can't just have reward. If you do not achieve to your target, there should be a sanction.
Okay. The other question that maybe you need to discuss is the issue of financial accountability. There are three words that you normally use in public service: source, spend, and account. As the chairperson of the commission, the buck will stop at you in terms of financial accountability. Would you expound a little bit on source of the funds, spending on the fund, and accounting for the funds? What will guide you?
Yes. I'll be guided by the law as always. The source is really no other than National Assembly.
National Assembly.
I will do everything possible at the earliest opportunity to engage with the Budget Committee, as you are aware, as a former very resourced person in it. You start off at the Budget Committee, you go to the Justice and Law Committee. Equally important is the Speaker of the House.
Okay.
And then from there you go to National Treasury with the Cabinet Secretary, so that everything is done. But allow me to say this, Commissioner. It pains me to see that the Treasury Fund has never been made operational.
We are coming to that.
Ah, good.
Go to the next spend. You have sourced the money?
You've sourced the money.
Yes.
But you see, you can source the money and it's a budget item, but it's not been given to you, which therefore means CRJ has got to make endless trips to Treasury for releases which are done piecemeal. That in itself becomes a problem, because then the spending, you may not be able to absorb it.
Okay.
And this is one of the things that I found out when I was doing the Council of Governors case, that a county is given funds in June, you can't absorb it. So absorption levels are so low, 10%, 30%. So depending on your question about judiciary fund, if our funds are given like for consolidated or equalization, then our spending becomes, we are able to absorb up to 98% or 100%. Accounting is the
Now,
one.
before we come to accounting
Sorry.
council, honorable council, my interest is the chairperson of the commission. When it comes to spending the money, what is your law?
The buck stops with me.
Yes.
Although I will not micromanage on a day-to-day basis, we must have very clear, very, very, very clear spending parameters, what we are spending it for. If it is for construction, it's clearly earmarked. And these are not things that we simply assume they are being done.
Okay.
Yes.
I want to hear from you. What do you expect to get from your accounting officer as far as that spending is concerned?
Very well. I would want to see a budget.
The budget is there already?
Is budget. Number two, we have been allocated so much. What are we going to spend it for? Number three, the procurement processes.
Procurement.
Because if there are no procurement processes, then you are dealing in darkness.
Okay.
And you can't fly in blindness.
Let's go to accounts.
Yes. The account, we owe it to the people of Kenya to account to them. The annual report, the annual report that is generated, it is a legal requirement. We must table it to Parliament. And as a matter of fact, that is a document that shows what we have been given. We have accounted for it to the last cent.
Okay, let's go back to the judiciary fund, which is actually, it has been enacted, you have the regulations, but we are still not there. Now, as the chairperson of the commission, I'm very interested in terms of the operation of that fund, and in terms of your strategic partnership, what will you do to at least to ensure that that fund gets the money that is in operation?
As I was preparing for this interview, I took some time to understand why what is as obvious as day follows night has not taken place. And one of the things I saw is that there's an argument about the Public Finance Management Act requiring this and requiring that.
Yeah.
Being a lawyer more attuned with the Constitution, I will engage the other stakeholders.
Specific stakeholders?
I will engage National Treasury.
National Treasury, what level?
Sorry?
At what level is the chairperson of the commission?
CS.
CS, yes.
Speaker of the National Assembly. I don't know who other person is. Maybe the Auditor General. I also saw there is a reference to Auditor General. And whoever other is key person is a key impediment to the act being operationalized.
Okay.
And I would want us to understand that judiciary fund is no less than equalization fund. And they are set up by the same constitution. So let us not play statute law as a way to impede judiciary to have financial autonomy.
Okay, Council, since you have talked on that issue, if you look at the Constituency Development Fund, at least they allocated 2.5% of the revenue. Now, in terms of the judiciary, we are not yet there. I would like to hear from you as a chairperson of the commission, and with all those other strategic issues that you have, how do we ensure at least we are very clear, we are predictable, and you know that at the end of the financial year, we either have 3% or 1% or 5%, so that when you are budgeting our programs, you are certain that the money is going to be there. Yes. How will you do that?
Yes, I would agree with you, Commissioner. It will be very good to have a degree of certainty what your allocation will be. And I've seen in one or two papers of a suggestion of 2.5% of the annual budget. How will I get there?
Yes.
Is the same way I indicated. I will engage with other players in it. You see, I think here, and I believe Commissioner Gishohi, you can understand me. Sometimes we react to a situation which has already happened. And I've seen persons going to complain to Treasury after the budget speech has been read. I mean, as your commissioners are aware, budget making starts in August. So in a few months' time, the budget making process for next year will kick in. And there will be a minister's speech. After that, there are so many key statute procedures that immediately start. So if you wait until the budget day and say, look, I wasn't allocated, it's far too late.
Okay.
So I'm sure I'll engage with CRJ, with the other directorates, and we'll engage National Assembly, if not August, earlier than August.
Okay. Let's go to something else. Devolution. What place do you see the judiciary in terms of our devolution process? And when you're discussing that, if you are invited at the summit, she brings together the national government, the county government, the president as chairperson of that summit, and you are invited in that summit as the Chief Justice. Could you share with us two issues that you would be able to articulate on behalf of the judiciary in terms of justice delivery in our counties?
Yes. Having worked for the Council of Governors, again, I see that as a seamless exercise. I will request the county governments to be quite ready and willing to allocate land to judiciary.
Like allocate land, yes.
Allocate land to judiciary for us to construct courts. They may not be the mammoth structures of High Court. They may be as simple as magistrates' courts. But the beauty with that is this. We have a constitutional obligation under Article 6 to take our services as close to the people as humanly possible. That is a constitutional imperative. So, Council of Governors or governors should not expect us to go to the marketplace to look for land and buy land. They have lots of land. We are doing this for the people within their counties. And I would expect a very, very easy, seamless interaction with all the county governments.
Apart from land, what else?
That is what I would immediately expect. Then, needless to say, I would expect that if we are constructing the court, they will be our partners, will educate our people, they will help us educate their people of the need to access our services, and more important, the need to be partners in our courts as users and as beneficiaries of our systems.
As a person who lives, some of us, in our rural areas, Nairobi appears very distant. And most of the services that are sought by our Kenyans are up there, 90% in our rural areas. And in terms of settlement of small cases, small disputes, we have very big challenges. If you become the Chief Justice, I'd like to hear from you in terms of the establishment of these small claims courts. I do realize that you did allude to that earlier on. But I want to be very clear. Will it be part of your first agenda in your platform?
Yes. Because small claims court, Commissioner, are a win in many ways. Currently, the backlog that I think we were discussing with your colleagues, the backlog in our system are those claims. Claims of 500,000, claims of this. These are the kind of claims that could very legitimately be transited to the small claims court. So it is actually a long overdue activity. If it could even be implemented tomorrow, all the better. And immediately you see from a case backlog of, say, 200,000, you may reduce that by 100,000. So this backlog is something that needs a very comprehensive view. Because if you take, say, 100,000 cases from the magistrate's court, then you free them to deal with the cases which are beyond the pecuniary jurisdiction.
So, Counsel, you're saying that in case you get this position and within 100 days, still be around here, God willing, we shall be able to see this small claims court on and running?
Immediate. They should be immediate.
Okay.
They should be immediate, as quickly as humanly possible.
Okay.
And they are not difficult to do,
Okay.
as I understand it.
Before I go to my final question, I want us to look at communication strategy. You see, communication is very, very important, both internal and external. And if you don't tell your story, somebody else will tell your story. If you get the position as chairperson of the commission, I would like to maybe share with us 2 steps that we want to take to enhance our visibility, our communication with our stakeholders, both in government and also the public. Communication strategy.
The communication strategy starts from what is our mandate.
Mm-hmm.
And since we know what our mandate is, we know who we are addressing our communication to.
Mm-hmm.
As to whether we have a web page or whatever, those are details that one can work out.
Mm-hmm.
But as you very rightly say, we must tell a story. What is JSC doing?
Mm-hmm.
For example, you have done so much
Mm-hmm.
in employment of judicial officers.
Mm-hmm.
I can't remember what numbers they were in 2011 and what numbers are today. I think for judges, today they are in excess of 150. For magistrates, there are so many. That story is not told.
Mm-hmm.
And yet it is the achievement of JSC. You have done wonderfully well in even disciplinary cases. Again, that story is not told.
Okay.
These are things that JSC, again, must bring sunshine, because you don't want to be seen as a moribund institution that doesn't do anything, when the truth is you have done so much.
All right. Let's talk about ethics. And I read a lot from what you have written up and other issues and the way you are described by your referees. And I want you to focus on what we call personal conduct for individuals and a kasha, a corporate kasha, the kind of kasha that you like to see the judiciary have, corporate kasha. Would you be able to share with us? Corporate kasha, values.
The corporate culture I would wish to have to see in judiciary is, number one, sensitivity.
Sensitivity. Mm-hmm.
Let me explain to you why I picked that as number one.
Mm-hmm.
Being a Kenyan, I think I was horrified when I read the story of a gentleman called, I think, Murage or something like that, who had smuggled his little infant from Kenyatta National Hospital in a paper bag.
Yes.
And what we did as judiciary is open a file for him and give him a suspended sentence of 3 years.
Okay.
That is not what I would want to see in judiciary. We must be sensitive, because that gentleman, all he required is intervention, not even at our level, but at a public national referral hospital.
Okay.
So sensitivity is very important.
2,
Number 2, it is accountability.
accountability kasha. Yes.
We must be fully accountable.
Accountable.
We should get out of that era of giving judgments which are incomprehensible, giving ex parte orders that persist forever, where we now see that we are we are responsible and accountable. Whatever we do is for the betterment of the common good.
Okay. Just before I finish, you are at liberty to answer this question. We have crimes or offenses that are across the borders, or international crimes, that if you commit this offense in this country, or other countries that we know we have agreements can actually get hold of you. We had some cases, I think 2 or 3 years ago, some cases that have been going in here, wildlife offenses, drugs, if you can call it. The drugs in our courts for, I don't know, 10 years and the rest. And when those people appear in those other areas, within 3 months or less than 3 months, those cases are concluded and finished. I know you talked about delayed judgments and the rest. I want to be very clear. What one thing do you do to ensure that internationally we are seen to expedite our delivery in terms of the cases that come to us that affect even other nations?
Even the crimes that don't affect other nations, even the crimes that just affect us. For example, public looting of funds. Those just affect us to a large extent. In all those cases, the penicillin for it is this: quick disposal of the cases. But when the cases are held at the are not to be resolved in the near future, then you see somebody is delaying and doing all manner of things, and that is I know the case you have in mind. You go to a different jurisdiction and you know that you have a hearing next month, just like Floyd, the case I think Commissioner Macharia was talking about, and you know that your lawyer is not going to say that he had a headache the day before, because for the simple reason the hearing will go on.
Okay.
So that is the whole idea. And when Costa Rica did this study, and it was an empirical study, they actually found a complete relationship between quick hearing of criminal cases and reduction of criminal activity.
Finally, Madam Chair, this is my final question. When you answer the question from the Honorable Attorney General on corruption, I really appreciate that. I wanted to hear from you, both internal and external, perception or otherwise. Do you believe that there are some cartels that you need to clear from courts that are actually hindering service delivery, justice?
It is possible. At the same time, it may not be correct. So, what I can promise this commission is this: I hold nobody's brief. I'm my own man. I'll come and do what I've been known to do. What I am, Commissioner Gishohi, is hard work.
Hard work.
It's just hard work. Okay. And I'll come, if there are cartels, let them know as soon as I'm sworn in, their days are numbered.
Thank you, Chair. Thank you, Council.
Thank you very much, Commissioner Gishohi. Thank you, Senior Counsel. Senior Counsel, when you asked the question about the source of funding, I heard you talk about exchequer. Would you try to get money from other sources?
Ideally, Prof, a judiciary ought to be funded by the government. Ideally, we should be a bit hesitant with external donors. But when need arises and we need external donors, I'll be the first one to seek their assistance. I must also say, in whatever activities that I'll be thinking of, I'll of course also want to work with civil society. There are some civil society groups that are of wonderful influence, who have wonderful literature, and it will be best we work with them. We are foreign donors, yes, but ideally, let's look at Wanjiku to be the person to fund us, because we are here for her.
Thank you, Senior Counsel. Next is Honorable Commissioner Koske.
Thank you, Chair. Good afternoon, Senior Counsel.
Good afternoon, Commissioner.
Yeah, I'm going to pick up from where Commissioner Gishohi left, but I want us to look back, 10 years back. And the happenings that took place. Are there happenings that you can identify, 2, 3, 4, that will inform your administration in judiciary? Besides COVID, of course, is one, the pandemic is one of the happenings that may inform your administration may shape and inform your administration. What other happenings can you recall that can really mainstream and shape the administration of Chief Justice Ngatia?
One is independence. Without independence, there is not much success you can have. I would want to be a Chief Justice that anybody in Kenya is very comfortable going to his court. Because in that court, they know that the justice of the case will be looked into. I would hate to be a Chief Justice where any segment of people are uncomfortable with my court.
Senior Counsel, I want us to have practical examples of what has happened in the last 10 years that will inform.
One of the practical things I thought is lack of independence, because that was...
Is there any situation, is there anything that you saw that happened that you seem to believe that it was because of lack of independence?
Yes, as you recall, in 2008, a candidate refused to come to our court and opted to go to the streets.
Okay, so that is one.
Yes.
Next. What other? Yes.
The next thing is that I would want, or I would look for judges who have fidelity to their oath of office. Fidelity meaning that really it is the case and the case only that will guide their decision.
Yes.
I would want to have the finances of judiciary ring-fenced.
Yes.
And the beauty with having judiciary funds ring-fenced is we don't need to be going to Treasury every now and then, because by doing that we'll never be able to achieve our objectives.
Mm-hmm.
So if we could have our revenue ring-fenced, then we are able to budget for it, to plan for it. That way we are going to achieve our year's planning and whatever we intended to do. And I'm sure in this, Commissioner, you would agree with me, there's no point of us getting budgetary allocation a month before the end of the financial year. We would want to have this right at the word go, and that is what the Constitution expects.
Yes.
Yeah, and those things, particularly the last one, it's not just the last 10 years, they are still happening to date.
Any other?
I think those would be the ones at the top of my mind.
Okay, thank you. You've said that you've been a consumer of judiciary services, and you've practiced across from magistracy courts, high courts, up to Supreme Court, and you must have. You must be one of those who have experiences, who can tell how judiciary operates. And I wanted us to focus on customer service. The public more often complain that judiciary is not good in terms of customer service. Long turnaround time on payment of fines, refunds of bails, and several other services that would ordinarily be, instant. But when it comes to judiciary, they say it becomes very complicated, even to have a customer service desk to direct people is a big problem. So, as a consumer of services of these institutions that you are now planning to come and head, what challenges have you faced as a consumer of services, and what probable solutions are you bringing in to sort out those challenges that you are facing as a consumer yourself?
Yes, Commissioner, you've hit the nail on the head. Some years ago, and we can talk about this openly, you'll be given a bail of so much amount of money, but I think it will be so deliberate that since the file is still with the magistrate, you can't pay the bail. And ultimately, you end up being in remand not because your relatives didn't have the bail money, but because of inbuilt, insensitive processes within the court. That has largely become a thing of the past. Not that we still have room to improve. Look at the fines or the refund of the same bail. You are acquitted of the offense, your 500,000 has been with judiciary for the last 20 months or whatever. To get it is another laborious exercise. In my view, it should be as simple as a cash or at a bank account. You have the acquittal, is in the court file, you have your original receipt, you have your ID, you should be able to get it instantaneously. Why are we still operating a very archaic process of making somebody go to the cash office for countless number of days? These are things that we should work with very, very quickly and see what processes and what interventions we require to do. And really, it's a question of, we go back to sensitivity, to sensitize our own people. A desk at the entrance of the court, and I see this happening in a few courts, a customer care desk, and just telling people, your court number 1 is this side, court number 2 is this side. It may appear very small, but Commissioner, let me assure you, it's the biggest thing that would happen. I'm sure you have traveled overseas. To be met at the airport makes all the difference. The consumer, our Wanjiko, is coming to Kibera Court for the first time. She has no idea where court number 6 is. If we have an attendant to just tell her, Wanjiko, you go to first floor, turn to the left, that is court number 6. That cost nothing, and that really is a wonderful face of the judiciary.
Thank you. Now, judiciary has been blamed and has been blamed that it is a threat to economic growth. Even last week on Friday, there was an article on one of the newspapers by Nganga Mbogwa, who, I quote, Kenya will perform poorly unless JSC picks a person who thinks business, even as he or she ensures the wheel of justice continues to grind. And judiciary seems to require now a head who will come and think business, who will work closely with the executive in terms of ease of doing business, who will work closely still with legislature to ensure that this country becomes attractive to investors and thereby, creating, jobs for our youth, and at the same time creating wealth. What is it that you are bringing into judiciary that can really help in transforming our way of doing things to the extent that it will be a destination of choice when it comes to investment?
Apart from investment, let's look at the broader picture of economic growth, because I'll also deal with investment in a minute. It is true, because of the way judiciary has been doing its business, and doing its business is a case is filed, it is processed. We never take the effort to look at how much we are locking up in that file. Look at it without again mentioning names. If you are to look at the estates locked up in controversy for the last 30 years, estates of deceased persons locked up in controversy for the last 30 years, is billions and billions and billions of shillings. It takes very little effort to see how you can unlock that wealth. That's number one. Equally, in commercial disputes, and I'm here, I would wish to say the commercial division of the High Court has done so well. They're trying to unlock the cases which are locking up lots and lots of money that would otherwise be freely in the circulation. Yeah. Commercial destination, yes. We can be a commercial destination, but we must also do what we are supposed to do. We must make our law productive and an incentive to dispute resolution. The minute we keep on a flip-flop, whether arbitration is final or not final, will never be a good investment destination. Any investor wants to look at a country that, you know, if I have a dispute, I go to arbitration, because in arbitration the beauty with it is it's a commercial decision being made. You don't want to be remembered for posterity about a very refined legal argument. So Kenya must make a very deliberate effort. Are we going to have arbitration as insulated from judicial intervention? And if we do that, then we can go to the next level, have an arbitration center. I'm sure the Honorable Attorney General is very busy on trying to create an arbitration center. But that center will not attract business until the other level, the other tier of is arbitration final concluded. And if we do that, you find actually foreign investment is coming quite easily. And even for us as local people, you unlock a lot of wealth, which is now locked up in unnecessary court cases.
So what solutions are you going to give? Can you break it down and
yes,
go direct to...
I'll break it down.
Yes.
For family division, all the people who have had their estates locked up before the lawyers who are now acting for them, before they were born, I'll allocate 1 or 2 or 3 judges to hear those cases to conclusion, because that is so important. We cannot allow that we are now going to the 4th or 5th decade after the departure of the testator, and those cases are still locked up in controversy. I'll do everything I can to resolve this issue of arbitration, because once we resolve it, then the executive will be able to set up an arbitration center, and that will be an attractive investment to foreign investors to come and invest in this country. A lot of it rotates around what we want to do. And all the time, unfortunately, Commissioner, we go back to Singapore. They had all these things that they could do. Why did they do them right? They did them right because they took a bold step and said, on this is the way to go, and they went for it, and now even disputes are being taken to Singapore.
Thank you. My final question is on community service. I've seen that you're really busy. You involved yourself more and more on community service, right from home to Nairobi. You are even supporting a hospital and chairing even the Alamano Center construction. What drives you? What motivates you in focusing more on community service? Is it because you are running away from conspicuous consumption, or what is it that is driving you towards that direction?
I'm not running away from anything, Commissioner Waziri, at all. What you see is really the same person from January to December. It is not a hospital, it's the hospice.
Oh, yeah. Yeah.
Hospice is a center for palliative care for the terminally ill. I support them wholeheartedly. I'm very, very close to them. I work programs with them. You'd be surprised, Waziri, for 50,000 shillings, that would be enough palliative medicine for 1 or 2 patients for the next 2 to 3 months. I look at it because I share in the divinity of every human being. We are all one people. And it's very easy to forget our brothers and sisters in the hour of need. When we do that, we lose ourselves. We are united as a people. We are united in times of distress. So I do a lot of work for them. I am a practicing Catholic. Currently, I'm the chairman of Kamwenja Teacher Training College. I was requested by the Archdiocese or the Archbishop to do that work. I am doing it because a request from my Archbishop is really a mark of trust. I'm currently renovating our chapel. We are about to get the diploma teacher trainees, maybe in 2 months' time. I decided to renovate the chapel, and I do so many other activities at home. I'm the patron of my parish in Nyeri, and I do so many other activities. Am I running away from anything? Far from it. I do believe that we have a common destiny and a common humanity.
Thank you, Senior Counsel. Thank you, Chair.
Thank you, Senior Counsel. You talked of Nyeri. Is that your home county? Because I should have asked that from the beginning.
Yes, you didn't ask.
Yes,
Could I take this opportunity?
Yes.
I was born in Nanyuki. I went to primary school in Nanyuki. I saw Ole Kapalo, who was a big boy at Nanyuki Secondary School. I was so impressed by his skills. I then applied to join Nanyuki Secondary School because of Ole Kapalo. He was more or less a mentor to me. It's after that I went to Nyeri High School. And may I also say this, because some of these things need to be said. A lot of boys in Nanyuki Secondary School, as Professor, I'm sure you may be aware, the catchment area is like Kipi, a bit of Nyeri and Aberdare. These are the areas that had been ravaged during the independence struggle, ravaged to the bone. So a lot of the parents did not have the means, but we had a very good bursary scheme founded by the first president, and most of us, including myself, our teacher or the person who paid for us is the bursary scheme. You went to the district education office. If you had good grades and you had been appointed to a government school or you had been admitted to a government school, there will be a bursary. But as you remember, maybe you may not remember, Prof, school fees was something like 450 for the boarding school and 250 for the day scholars like me. So with a bursary of 200 shillings from the district education office, we were able to go through our education. So I am forever grateful to a safety net that was created by the first president, because that is the one that enabled a lot of boys in Nanyuki Secondary School to see the end of secondary school. As we were going to A-level, school fees for A-level was abolished, again by the first president, so we were able to do A-level without any tuition. University of Nairobi, there was a scheme which was the boom, which we used to get every term, and for which I have repaid to the full cent. So to a large extent, good processes, good procedures in government are able to see even those who are not endowed go to the highest level in life. So for any young people who are listening to this, it is possible with hard work, with perseverance, to aim for the very best. Kapalo and I are united in saying it is because of those timely interventions that we became what we are today.
Thank you, Senior Counsel, for that additional information. So we can record your county as, is it Nanyuki or Nyeri?
I'm born in Nanyuki. That's my county of birth, but my ancestral home is in Nyeri. So I'm owned by two counties which are next to each other. So I cannot denounce my ancestry. I do a lot of work in Nyeri because that is where my ancestral home is.
Which county is in your ID, Council?
Laikipia.
Also, I don't know what to record. Is it Laikipia then?
I think we go by the home place I was born is Laikipia.
Okay.
Yes.
Thank you. And your name betrays you, so we record your Kikuyu by ethnicity?
Yes, I am. Also, I should be more of a Kenyan, but I'm a Kikuyu by that tribe.
Yeah, we asked this question, Senior Counsel, because of the requirement of taking care of diversity. I'm sure you're aware.
Correct.
Thank you. Yeah. Lastly, now is the turn of Honorable Commissioner Evelyn Orwade to ask you the last set of questions. Commissioner Orwade.
Thank you very much, Chair. Good afternoon, Senior Counsel.
Good afternoon, Madam Commissioner.
I have a few follow-up questions before I ask the questions that I had for you. I'll start off with, Columbus is said to have discovered America, even while the Red Indians were in it.
Yeah.
In the insider-outsider debate, you've described yourself as an insider and not an outsider. And I think you're entitled to your opinion. But you set yourself apart, if I understood you correctly, when you drew the analogy of the Chief Justice who put an end to racial discrimination. Essentially, your message or your point is that you bring in a fresh perspective. Now, I've been listening to you, Senior Counsel. You have quite well put the ailments that belabor or beleaguer this institution. But your interventions, most of what you have said, is what is already happening in the institution. You've spoken about accountability of individual judicial officers. We already have the daily court returns that we file on a daily basis to account for the work you've done on a given day. You spoke about a cashless system, which is already up and running. You spoke about identifying some judges to concentrate on backlog. We already have that in the form of service weeks. You've spoken about automation. We're already rolling that out. You've spoken about inculcating ethics and values. We are forever attending trainings, are forever going on retreats, basically doing just that. On motivation, you spoke about a medical scheme. We already have that. So what I'm wondering is this. What is the fresh perspective, the innovative strategy, the practical thing that you bring on board as Chief Justice Ngatia?
Number one, I think, Commissioner, I didn't describe myself as an insider. I said I am a user or a consumer of the services.
I stand corrected.
Thank you. Not that it's wrong to be an insider, but I never got the opportunity at the right time. Mm-hmm. Alternatively, I was not available at that time. In my first 100 days, I would have the equivalent of JT, Judicial Transformation Framework that Chief Justice Mutunga did. I have already identified what I'll call it. I'll call it expeditious disposal of cases. In that blueprint or in that transformation agenda, I'll be able to come up with pillars of what, with your assistance, we hope to be able to be transformative. True enough, there is access to justice. True enough, I concede that. But access to justice has two elements, qualitative and quantitative. Access to justice has also certain drawbacks. You may build a court, which we already have done in Nyeri. Are we content to say there is access to justice because of that court? I'm looking at the next development, which is an expedited delivery of the court cases in that court. So I would go on record as saying this. Very nice framework policies are in place. Fantastic. But we need now to refine them and to see out of those framework which are the areas we can take to the next level. In those framework, expeditious disposal of cases is not given the prominence I would wish to give it. I would wish actually to come up with a timetable of from filing to conclusion, what period of time are we talking about? I know about backlog, it's there, we are doing everything possible, but we can do much more on that backlog. We can reduce the cases in the courts, magistrates' courts, by having small claims courts. And those small claims courts may take a huge bulk of the backlog of those cases. So it is not something I would have done, a transformation agenda I would have done as a practitioner, because I would not be able to have access to the full range of the literature which you have and which I don't have. But I can say that I'll be able to work on that, and with the effort with the participation of all the other players, be able to roll it out within 100 days. I think that's what Chief Justice Mutunga did, Chief Justice Maraga did, and that is what I'll be able to do.
And Chief Justice Maraga also gave a time frame within which he had hoped we should be able to deal with backlog of a certain number of years.
Correct.
Yes, so I take it that what you're bringing on board is basically to refine what we already have in place, the strategies we already have in place.
And to improve on it. Not just to refine, but to improve on it and to bring maybe another dimension or another angle of resolving it.
Okay, thank you. I think another thing I want to say on the issue of backlog, not necessarily as a question, but just to set the record straight over something you had mentioned earlier about dismissal of dormant cases.
Yeah.
You mentioned something to the effect that it's like running away from the problem. I just feel the need to correct the impression created, because it is true that on many occasions, Kenyans will rush to court with their cases. Somewhere down the road, maybe because of intervening circumstances, they choose to abandon those cases.
Yes.
So I think it's a very useful strategy to do away with dead cases in our registries, just to set the record straight.
Could I please?
You wish to comment on that?
Yes.
Okay, feel free.
And here I'll start guided by my Lord Judge Majanja. I think a lot of cases, particularly in commercial, are won or lost on applications. So I would agree with you. If somebody goes to court, commercial division, does not get the injunction to stop a bank from realizing the property, and the property is realized, the chances of that person going back to court are almost zero. So you are quite right. It's the procedure in which we invoke to get those dismissals. If we do dismissals summarily, then what they do is they provoke applications for reinstatement. I am in agreement with dismissals, but we must be with due process. And sometimes I think in a service week, there's a service week, I remember I did a bit of looking at, not really research, but from that service week there were so many dismissals, and the following week there were so many applications for reinstatement. So it's a question of how we do it, and we do it correctly. But at the end of it all, much as we do dismissals, there are still those cases that we must handle.
Okay, I've heard you on that point. Before I ask you the next question, Senior Counsel, I would wish to ask you, how many associates do you have in your law firm?
Currently, because of what we are going through, I have 3 other lawyers.
3 lawyers.
We upscale as depending on the type of engagements we are involved in. I have led teams of up to 30 and 40 lawyers. I upscale depending on the activities. Currently, as of today, I have 3 other lawyers, so we are 4 lawyers.
Okay, thank you.
Yeah.
Senior counsel, in my view, you put it quite aptly when you said that the most critical of the Chief Justice's role is to be the head of the judiciary. And you must agree with me that the dynamics in leading a team of, say, 10, 20, 50 lawyers is different from the dynamics of leading an institution, an arm of government that has over 5,000 judicial staff, slightly over 500 judicial officers, and about 200 judges. In your experience, or what you have experienced in your legal life, do you think you are well equipped to handle that kind of responsibility?
Yes, Madam Commissioner, as I indicated, the tools you use to manage Safaricom with so many millions of subscribers are the same tools you'll use to manage another company with a fraction of those subscribers. Consequently, we cannot set as a must-have done somebody who has managed, say, 10,000 people to be the only potential CJ. All over the world, Kenya included, we've had CJs who have not had any leadership of an institution. The most pronounced Chief Justice, Professor, is in prior 2010, is Justice Madan. Any Kenyan would remember Justice Madan. Judge Madan was just a judge. Never ever did any administrative work. He became the most pronounced and the most remembered judge in the history of Kenya. Closely followed by somebody like Justice Apalu. Justice Apalu was just a judge and he was appointed a Chief Justice. Had not even run a registry of 2 people or 3 people. Those 2 justices served for a period of 2 to 3 years. They left a mark that is everlasting in this country. I do not think, in my humble opinion, that a person who has had an administrative or task force of so many people will make a better Chief Justice than one who has not. And you can check this across the world. But we don't even need to go further. Kenya in itself is a wonderful example. And starting off from the first Chief Justices, and I'm sure here Commissioner Attorney General has a better history than I have of the Chief Justices who are well remembered and who had not ever held any administrative task in this judiciary.
Thank you. Thank you for your response. Now, moving on to the questions that I had. What is the position of a prospective parent in a surrogacy agreement when it comes to rights, parental rights and responsibilities?
Please say that again.
The position of a prospective parent in a surrogacy agreement in respect to the rights, parental rights and responsibilities.
Surrogacy is one of those very decisive topics. I've dealt with it slightly in my dissertation. The difficulty, Commissioner, as you're fully aware, is what rights do you have? All you did was to say enter into a commercial agreement with a young lady that she will carry the kid for you. This young lady midstream decides no, she's not going to give up her child. She's the biological mother. And those surrogacy arrangements, and at the appropriate time I think I'll write a paper or 2, are very, very decisive topics. In America, this has been the subject of raging controversy, which has gone up to the Supreme Court. Because you who gave the mother the money, you feel entitled as of right. But on the other hand, the biological mother feels, and she's perfectly entitled to feel, that this is the womb, the child of her flesh. So what rights are they? That is something that really one cannot be able to define with any accuracy, because for one answer, you get two different answers.
Senior Counsel, our courts have made some determinations around that subject, despite the fact that we do not have a formal legal framework to deal with those agreements.
Correct.
And I would just love to hear from you how, according to the decisions that have emanated from our courts, how, for instance, a prospective parent should go about acquiring the rights and responsibilities of a parent. For instance, how he should go about getting his name registered as a parent, which of course comes along with the rights and responsibilities of a parent.
Why I indicated that for one answer you get two contra answers, I'm aware of the case. Maybe there are more cases than one. I've been requested to give an opinion for purposes of going to the Court of Appeal. So I'll be a bit hesitant to go into it, but definitely what we can say, and here I think, Commissioner, you would agree, that is not the last word. That decision has not been tested at appellate level, and because of the constitutional underpinning of it, in case I were to go on with that brief, I see myself ending at the Supreme Court. So I'll be a bit hesitant to talk about it, but it is really not a last word on that issue.
Very well, Counsel. We can move on to the next question that I have.
Yes.
What are the Bangalore principles of judicial conduct?
The Bangalore principles, I do remember them. They are 6 in number. And these are for the judges and also for the judiciary. In the sense that judiciary is supposed to craft a code of conduct around those principles. Independence is one of them. I think the next one is impartiality. That is natural. Equality. The fourth would be propriety, how the judge holds himself, because how the judge holds himself in public and in private is so important. Then the next one is integrity, and then competence. And to me, if I could pause there, Commissioner, competence becomes so important, because to have a judicial officer who is incompetent is to put an aircraft in the hands of an unqualified person. And then the last one, I believe, is diligence. Diligence, and judiciary, and for that matter, JSC, would be able to craft a code of conduct around those principles, as I understood the paper that I read.
Thank you. You've actually moved on to answer my next question. I was about to ask you what is the legal status of the Bangalore principles.
Yes.
Maybe you can say something about that.
Yes, the legal status is that really this is something that has been agreed upon, and they are repeated all over, and judiciaries or JSCs are supposed to craft their code of conduct around them.
Thank you. Now that you say you did some reading around this, where and when was the idea of having the principles first conceived?
I think it's got a long history. There was a Harare Convention. Before then, there was a meeting, I think, in the United Kingdom. There appear to have been quite a number of meetings discussing this. I may not put my finger directly to the first one, but I could see this, a lot of engagement. And maybe even after Bangalore, there could be subsequent engagements.
Okay, thank you. This is a question that I have got from your introduction. You talked about being involved in some kind of framework, developing some kind of framework of the disciplinary process at the University of Nairobi when you started off. And I just wanted to ask you, because I imagine in your brief at that time, you may have encountered something to do with the subject of student activism or youth activism. What is your position concerning that?
Activism at that level is naturally expected. Youth activism is a phenomena that any university must expect. I also did a bit of work for our Catholic university. At that time, we had clergy who were in charge, and I had really to take the clergy through a process to tell the clergy, look, please remember the students are secular. They are not part of us. They are not part of the clergy. So it is something that we must expect. We can't expect anything less than youth at that level having some activism. What I find difficult to understand is how we as a university then reacted to that by being very insensitive and having disharmony in how we react to it. So a student found, for example, having done ABC, is expelled by one college, but for the same offense, he is reprimanded. You see, the minute, even for us as lawyers, we see disparity in the sanctions we get, you naturally getting counter feelings that no, so and so was favored because his father is rich. So activism, true enough, it was there. And I'm sure even during our times at the university, there was a lot of activism.
Thank you. Thank you very much, Senior Counsel. Now, my next question touches on matters that border on welfare and employee motivation. I'm sure you did quite a bit of preparation when you made up your mind to apply for this position and even as you were coming for the interview. And in that preparation, I expect you may have interacted with some of the welfare concerns that the members of the judiciary have. Am I correct?
Correct.
Thank you. Now, we have a scenario that is causing a lot of concern, especially amongst the judicial officers. We know that under the Constitution, in terms of post-admission experience, the required experience is 10 years. By the time a member joins the judiciary as a judicial officer, as an RM, resident magistrate, they are required to have about 3 years experience. If he's lucky enough to get promoted at the next interview, but if he is lucky, comes after 3 years, he would be having 6 years experience. By the time he's PM, if he's extremely lucky, he will have close to 10 years experience. When jobs for interview, or rather when jobs for promotion or appointment to the superior courts are advertised, of course the cutoff required experience is 10 years, just as is provided in the Constitution. But you will find this magistrate is still far below the hierarchy of ranks that is required to go through before he can ascend to the High Court. Invariably, members who should be promoted to the High Court will be picked from the Chief Magistrate level. So that by the time you even qualify for consideration, you will have pumped in no less than 18 years in this institution. Yet out there, shortlisting is done based on 10 years post-admission experience. This eventually also brings in another problem when it comes to the pay structure. Because after putting about 18 years in this institution, your level of pay may not necessarily be at the entry level for judges. But you'll have this fellow, maybe from private practice, after having 10 or 11 years experience out there, coming in and objecting to your higher pay. Those are issues we've been grappling with in the institution. So there is that concern that the application of the cutoff post-admission experience is applied discriminatorily. But then again, we have those challenges. Are we going to open it up for RMs to compete with chief magistrates for promotion to the superior courts? How are we going to address that challenge under your leadership? What creative interventions would you come up with that will satisfactorily settle this issue in a way that will be acceptable to all people on both divides?
Again, it's unfortunate this discussion goes insider and outsider. It's so unfortunate because if my view is allowed, I'll still go back to the word of merit. I would hate to ever hear a magistrate saying, if lucky enough, I was promoted. I would actually be doubly hurt to hear the phrase, if I'm extremely lucky, then I'm promoted. My promotion policy would be based on nothing but merit. Merit would be the only consideration, not luck. Consequently, it's important really that a peer review is in place so that a magistrate at court this and a magistrate at court that, this other one, you are able to independently verify how hardworking and meritorious are their output.
I'm sorry, Council, if my words sort of created a confusion. When I was talking about luck, I wasn't talking about people getting promoted on the basis of luck.
Okay.
I'm talking about luck in terms of coming up for determination for promotion.
Very well.
Yes.
Thank you. So, because it's merit-based, I would want to see a situation where when a magistrate has done 10 years or 11 years or whatever number of years, that magistrate has an equal opportunity with somebody in private practice to apply for a job, for appointment as a High Court judge. I would not want to hear or to wait until a magistrate is at the level of the chief magistrate to be able to say it's only at that level that you can apply. Because the Constitution defines it's 10 years, isn't it? So why is it we are putting other barriers? Because these barriers become a hindrance only to a segment of the population. For a lawyer, there is no hindrance that you must have done cases up to this level to apply to the High Court. It is the number of years. So, because of this belief I have in uniformity and non-discrimination, I can assure you, Commissioner, in my tenure, a magistrate who has the required constitutional qualification, given the work done, would have an equal opportunity with any other person. As a matter of fact, I'll look more towards magistrates going to the High Court because it's also part of developing a culture of this a reward culture.
Thank you very much, Council. I'm sure magistrates listening to you out there are crossing their fingers for you, wishing you luck.
Thank you. Not that I would discriminate against advocates in private practice, but it's important that we do not discriminate against magistrates and then give a leverage to advocates in private practice. We must look at the merit and merit only for these judicial appointments.
Thank you. So now we can move on to your application.
Yes.
I noticed from the documents that, or rather the response we got from the vetting bodies, that you are not cleared by KRA, you are found to be not compliant. I just want to hear from you whether that, whatever issue that was there has been resolved, and if you can get communication to that effect that you have now been cleared.
I think, Commissioners, it's important I say this. Let this process also not have many other actors. I have a valid clearance certificate. Then I got communication from KRA that all candidates for this position must go there. I wondered why we all must go there despite our having clearance certificates. When my tax consultant went, he was told I have some penalties of 1 million shillings. I paid it, but I started seeing as if there is a third hand in this process. A week later, I was told, doing in-depth from 2015, there are some tax arrears. I have responded to it, and I have told Caesar that Caesar, you are entitled to your lawful sums, but nothing more beyond your lawful sum. We have agreed to do an ADR under the Act, and I have every intention to pay whatever is due. But I hesitate to say this. Do not let this process also have any other player. I was quite alarmed about being told to go there despite having a valid clearance certificate. But to answer your directly, yes, we are at ADR, and I've made every provision to pay whatever may be outstanding. For advocates in private practice, we have certain distinct disadvantages. You are holding funds for a client for purchase of a property. The client tells you put that money in a fixed deposit account. Once money is in a fixed deposit account, after 3 months, the interest is generated. And from that interest, there is a withholding tax. That withholding tax is paid directly to KRA. For KRA to assume that the money on interest is your income, and therefore expect me to pay income tax and VAT, you tell them no. It doesn't. Income which is not legitimate, then it becomes rather difficult to explain where that income has come from.
Thank you.
It's important for public officers to be able to be held to that very high standard. And I saw that in the Judges and Magistrates Vetting Board. The need for everything to tally. It's a tarrying process. And it's a...
With you in charge, despite your relationship.
Very good. Can we now, because this is the third time I've been asked this question, look at it from a different angle? It is true ICJ raised it. It's true Atheists Kenya raised it. But why is it that political formations are not raising it? Why is it that people who ought to be afraid if I was that associated are not raising it? There are so many emerging political formations I have engaged against in this country. So many of them. But they do know of my independence. They do know of my fidelity to my client. Each one of them knows that with me, I have nothing but fidelity to the work I am doing. Consequently, no political player, as far as I know, has said under Ngatia there will be no independence of the judiciary because of its association with so on. Because they know there is no that association. My fidelity will be to law. I have no preference in whatever happens in the political process. I have no preference to any case of any person against the other. I will simply be a Chief Justice who would do nothing but administer pure law. And that is why, Madam Commissioner, you see the 2 or 3 or 4, they all start off in so predicated or prefaced We know Ngatia is a very professional lawyer. We know Ngatia is a very hard-working lawyer. All of them. And I'm sure that is the common parameter with all of them. But then they say, could he explain? He will not be. And really, as I indicated, Kenya is beyond what is the current political dispensation. If I am appointed Chief Justice, if I have to do 4 or 5 years or 3 years, it will mean that I'll do it under two presidents. Consequently, I do not think, and I say this without any fear, I do not think any well-informed Kenyan sees me as an extension of the fourth president of the Republic of Kenya, because I'm not. There is no well-informed Kenyan who sees me as being compromised in any way by the fourth president of Kenya, because I am not. If you look at my CV, Madam Commissioner, you see from 2013, the cases I have done against government institutions. The cases I have also done for the government. And all those show a fidelity to law. For example, when TSC, my client TSC, was told to pay teachers a very hefty award of money that would have collapsed the economy, TSC came to me. And they came to me directly, not through the proxy of anybody else. And I did that appeal in the Court of Appeal, and I won on merits. Similarly, any aggrieved person by any arm of government, again is in my CV, you see I acted for him with the same zeal and the same diligence. Why? Because I practice pure law in my practice. That, I think, is what Kenyans have known me for. In my CV, you see from many, many years ago, I have only worked very hard for every case I have acted for. Whether I lost or I won, it was because of the hard work I did. And there's no lawyer and there's no person who will tell you that I was a political project of anybody in this republic, because I've never been.
Thank you very much, Senior Counsel. Kenyans have heard you. I've heard you. Thank you for being patient this afternoon. I wish you well.
Thank you.
Thank you, Chair.
It has been a long day, Commissioners and Senior Counsel. I want to thank you. So this is the end of this interview. Thank you for coming. Senior Counsel, thank you for your very honest and exhaustive and even passionately answered questions. We want to thank you for that. And on behalf of my fellow commissioners, Senior Counsel, wish you all the best. Do you have anything to tell the commissioner?
Yes, before you conclude, Prof.
Yes.
What I did, because Kenyans need to be told that a lot of good work is done in Attorney General's chambers, because it's so easy to condemn government agencies. I came with a map of Ilemi Triangle, which shows the area that we won for this country, which measures 9,680 square kilometers. This is the Ilemi Triangle. In this area, we have 2 constituencies. We have now established a lot of infrastructure, and all this was done under the guidance of the Attorney General, and the person who ought to get all the accolades is the Attorney General. I was only a faithful servant of the Attorney General. But what I've done is to prepare 9 copies for all of you. It is an important milestone, and this is to show that in whatever areas of our human activity, what matters is the diligence, the persistence, and the determination. With that, you can achieve anything in this country. I do not know of any other country in the world that has won as much territory as that, but there are many cases in my research paper that have indicated cases between Norway and Sweden, where the same principles of law are applied, and those principles of law have enabled me to come to that conclusion. In other words, Prof, there are indeed Kenyans who are dedicated to this country and who work for this country and work for this country relentlessly, independent of any other consideration. My last word is to say that this has been a wonderful session. I do not know what to say. I expected nothing less than what I got. It is a very invasive process. I didn't expect to be the subject of so many complaints by so many people about having conducted an election petition, which I conducted in open court in the Supreme Court. But there you are. The appointment of a Chief Justice is not an easy thing. It's done by the three arms of government, by judiciary, number one, by the executive, and more importantly, by National Assembly. So I am thankful, and you've treated me quite well.
Thank you, Senior Counsel, and thank you for this information, because a lot of us, personally, I didn't know about this, and I'm sure fellow commissioners, some of us didn't know. So thank you for, and even Kenyans. So it's good you brought it to attention, and thank you for that work you did for the country. Yourself at the AG.
Yes.
Thank you. The best. Thank you.